Well, good morning and welcome everyone. Today is specific day and time, Monday, January 30th, 2017. This is the Josephine County Board of Commissioners convening for a land use hearing on request for a text amendment to the Josephine County Rural Land Development Code. And if approved, the decision would allow changes to the Rural Land Development Code to address growing marijuana in residential zones. Other text amendments proposed help address land use conflicts that will arise as a result of the marijuana industry in Josephine County: fencing, plant location, oversight, building size, and overcrowding, odors, lights, waste management, noise, camping, runoff, and citation authority. So the meeting of the Josephine County Board of Commissioners will be conducted according to the Josephine County Land Use Hearing Rules as they apply to legislative actions. A summary of these rules is as follows. Number 1, the planning staff will identify and explain the laws and procedures governing this action. Number 2, if you believe any of the laws or procedures cited are not identified, followed, or correctly applied, you must raise the issue to the chair for a ruling. Clearly raise a legal or procedural issue in order to be understood by the board, and participants will prevent a later appeal. Prevents a later appeal of that action. Item number 3, all participants are free to express their views about whether the proposed legislation is good policy or appropriate use of county resources. Item number 4, any person who participates in this hearing may receive mailed notice of the board's final decision by requesting the notice in writing. Item number 5, participants are obliged to know and follow the rules and procedures. The planning staff present has a copy of the rules. Next, state the first item on the agenda as was previously read already, the item of why we're here. Does anyone object to the jurisdiction of the board to hear this matter? So that's up to you guys. There's quite a crowd. There's still some seats available. In church growing up, we had this thing, SOS, scoot over some. So if you wouldn't mind, for those of you who are in the chairs, if you could just scoot to the middle, that'll provide chairs on the outside for people. So if there's a chair in between you and the person to your right or left, please utilize it and scoot in. Let you do that, because there's people standing in the back and there are seats available for those who choose to sit down and utilize those. So, do one way or the other, that would be great. Thank you so much. We'll all fit in here. I've had a whole lot more people in here than this. Still on item number 7, does anybody object to the jurisdiction of the Board of Commissioners to hear this matter? Hearing none. Any members of the board wish to abstain from this matter? Did you ask a question?
It is not an objection, but I would like to question, but because I don't know, how regulation could be imposed upon patented lands.
It's a really good question, and our council's in the audience.
And I would find it incumbent that that this information be found out. I think that's important.
Okay, we will look into that. We may not have an answer for you right now, but we'll get one.
But if it's found that, yeah, thank you.
Yep, we'll work on that. I think Councilor Hicks heard the question. Patented land, you want to talk about it or do it later?
Let's keep going.
Okay, great. Any board member wish to object from participating?
No, thank you.
Great. So the Josephine County Rural Land Development Code sets the following time limits for testimony. Participants are, the staff report will be item number 1, and then participants will be item number 2. A is questions of staff, 5 minutes, and item number 3, comments from the public, 5 minutes. So you'll each be provided 5 minutes to address after the staff report and questions of the board and giving directions. So just so you're aware of that.
I know.
You'll just need to raise your hand and kind of let us know where you reside. Not the specific street address, but just the general locale is just fine. The laws and procedures, item number 9, the laws and procedures applicable to the legislative item shall be presented by the planning staff as part of the staff report. And we have Ms. Schmelzer to provide that. So, before you get out, Ms. Schmelzer, there was something I wanted to say to kind of set the tone for the meeting here. This process is probably a little bit out of the ordinary and was started by a previous board. So I was on that board, but these two members were not. They charged our planning staff with trying to come up with some legal recommendations that we could amend our code by. The Rural Land Development Code is the land use code that governs everybody in Josephine County. And from that previous board standpoint, there were some deficits created when Measure 91 and legislative item number 3400 were enacted in Oregon as a result of Measure 91 passing. And some challenges arose for land use issues in Josephine County. So the Board of Commissioners really didn't set out too specific of a charge to our planning director. I think in hindsight, if I would have done this a little bit different, I would have requested maybe we come back, have some refined discussion as just part of a board workshop, codify those elements that we wanted to move forward in an ordinance, refer those to the Rural Planning Commission, and then come back to us today. That didn't happen. So I'll just ask for everybody's patience in what's being presented here today. What's being presented doesn't necessarily mean exactly what we're going to either move forward. The board has the option to move nothing forward, move everything forward exactly how it is, or change the proposal and then move that forward. So there's actually a lot of breadth of options here. And all of those options, I believe, would be referable to the voters either by this body or yourselves. So it's kind of a long, sometimes cumbersome process. So don't think that this is going to be end-all, be-all today. Just ask for, again, your patience in this process. We're just trying to figure out a way to see how we could refine things a little bit here in Josephine County to make it hopefully better for everybody. So, is there anything that the board wanted to add?
I would just ask that everybody try to be respectful of anyone else testifying. And it may not represent what you feel as they're saying it, but we're going to give everybody an equal chance to share. And there's no decision being made today as far as this is law today. Everything that we're doing is to gather information, to get feedback, and we truly are grateful for you all showing up here today, but we also insist, please be kind to each other, and we'll be able to get through this much quicker.
Great, thank you.
Yes, I'd just like to add to that. This was handed to us for Commissioner Morgan and myself. We've read and read and read and read, and we've received emails and all kinds of stuff. But we're interested in what you have to say. That's what we're here for today.
Great. All right. I think that pretty much sets it. So, Ms. Schmelzer?
Bear with me because our slideshow doesn't work the way we had hoped. But my name is Julie Schmelzer. I'm the Director of Community Development for Josephine County. And I just want to go through, this is going to be a pretty lengthy slideshow here. We have about 52 slides. It's necessary to set the stage so everybody understands what authority we have, why we're doing what we're doing, and then the details involved in each of the decisions. Okay, first of all, there's been some question as to what we're doing, why we're doing it, so just a little background real quick. Zoning was set in the 1920s by then Secretary Herbert Hoover, and the purpose of zoning is they set the standard saying such regulations shall be made in accordance with a comprehensive plan, which we have here in Josephine County, and designed to lessen congestion in the streets.
Schmelzer, I apologize.
Yeah.
The gentleman who just put that cell phone up there, you're going to have to turn that light off. I don't mind if you record this, but that light is really not pleasant to look at and distracting from whatever Ms. Schmelzer said. It's okay.
Okay, such regulations shall be made in accordance with a comprehensive plan and designed to lessen congestion in the streets, to secure safety from fire, panic, and other dangers, to promote health and the general welfare, to provide adequate light and air, to prevent the overcrowding of land, to avoid undue concentration of population, to facilitate the adequate provisions of transportation, water, sewage, schools, parks, and other public requirements. Such regulations shall be made with reasonable consideration, among other things, to the character of the zoning district and its peculiar suitability for particular uses, and with a view to conserving the value of buildings and encouraging the most appropriate use of land throughout the municipality. So based on that, zoning was created in the United States. For Josephine County, we developed subdivision regulation in 1958, and as a county, we adopted zoning in 1973. That zoning code had many different aspects to it. At one point, it did have, actually when it was created, we had a violation section. I bring this out to you because I know this has been an issue in some of the letters, but we did have a violation process at that time. Purpose of the Rural Land Development Code, which it becomes important here. What we're doing is we're discussing amendments to the Rural Land Development Code. This is not an ordinance in front of us right now. These are proposed text amendments. If you decide to move any of it forward, that then would move forward in the form of an ordinance. But right now we're just talking about proposed text amendments to the Rural Land Development Code. And basically, when you look at the purpose of the code, it is to guide and manage the future growth of the county in accordance with the comprehensive plan, to protect public health, safety, and welfare, and to assist the public in identifying the codes. That's why we have the Rural Land Development Code. And therefore, when we're talking about proposed text amendment, we have to keep these things in mind. What is the purpose of the code when we look at these proposed text amendments? SB 1598 allows the county to set reasonable regulations on marijuana. A lot of people say, why are you picking on marijuana? It's because the state says that we can have specific regulations to marijuana, and they don't allow us to do that with other farm crops, but they do allow us by state code to do it specific to marijuana. Sorry, I told you this was kind of goofy today. So Commissioner here had mentioned the June 8th order or directive from the board, and it was to the planning director. She was authorized to initiate an application for review of proposed text amendments that provide for regulation of marijuana production in rural residential zones, which shall include but not be limited to setback and fence height requirements. And that is basically what set the stage for us today. That is what gave me the order to move forward and start developing those proposed text amendments, which we're going to talk about. So just a little background, there were 4 town hall meetings last summer. We also, that marijuana was discussed, marijuana regulation was discussed. We heard a lot of things at those town halls. One was basically medical marijuana is necessary. We kept hearing that over and over. Support the small farmer. They weren't allowed in their backyard. There was concerns about lights. There's a myriad of things brought up at those town halls, but basically it was pretty much saying don't regulate us. There wasn't very much what I felt was constructive comments at those town hall meetings. But we did receive a number of complaints. They were either by phone or by email or in writing, and they addressed such things as odor and nausea, fences, safety, concern over no licenses, water uses, and raw sewage, NIMBYism, basically people didn't want marijuana in their backyards. And then one of the big complaints we got was about compounds, which are camping establishments. We started seeing more this year, I think, than we have in the past, probably due to the guards that were occurring on some of the marijuana farms. But compounds are basically a general problem in Josephine County, regardless of the marijuana industry. So with odor and the right to farm, a lot of the complaints were about odor, and we as a county are very limited in what we can do regarding odor. There is a right to farm law that said basically that a county cannot regulate odor and noise, for example, in a farm zone. So when we started working on these rules, we kept that in mind. I will say that now, since we got into this, we became aware that the state now does allow a county to regulate odor and noise in a farm zone. That's not reflected in these proposed amendments because these were crafted before we became aware of that new law. So as I said, fences was a big concern for us. What we have seen is a lot of fences. Some of them are made out of tarps, temporary materials. Not all of them are made out of wood. We've seen some made out of root balls, down trees, stacked appliances, and stacked junk cars. So there became quite a myriad of fence composition issues out there. We received a lot of complaints about those fences. Safety became a big thing. It was how do you protect the crop was one of the issues. And then also from the neighbors with concerns over guns and vicious dogs and trespassing. Another concern that was brought up to us was the concern that people questioned whether people had their license from OLCC or their approval from OMMP. There was concern over water and waste. Those were three things that really are out of our jurisdiction. For recreational, those like, pardon?
Could you, I couldn't tell if you said are under our jurisdiction or are not.
Are not. Are not. The licenses come from the states. Although we do regulate water to a certain extent in the code, we do not for the aspect of water rights and water on crops. That's regulated by the states. And then with the waste as well, that's a DEQ matter. So we did receive a lot of complaints, but our hands are tied on those. So I'm battery.
Cold.
Battery's dying here.
Do you have a keyboard?
I do, but you know, here, the keyboard, you have to hold it up to do it. There. So compounds, like I said, became a big issue. We received a lot of complaints about compounds. Basically, a compound is where you have a conglomeration of campers out there. They also are the most difficult to regulate and the most difficult to get compliance on. Most of the compounds we're working on have been in excess of 6 months, and we haven't really seen any movement as far as people removing those campers or cleaning up the site that they were on. So when we began looking at these, we started to say, you know, we looked at the numbers at that time and said, where are we seeing most of the licenses or where is the activity? And what we were able to do is, we have no access to the medical marijuana records, but we do of the OLCC records. And we can look at where the land use compatibility statements have been submitted for. And just to back up a little bit, a land use compatibility statement is a form that the state requires to say that what the grower wants to do is allowed in that zoning district. It doesn't mean they meet code, it just says it's allowed in that district where the property is located. So when I was given this charge, as of June 8th, we had the majority of the lots that we had submitted were either in the exclusive farm zone or in the RR5 zone or in the woodlot resource zone. So those were kind of the three that we kind of honed in on and looked a little closer at as we started initially looking at the rules.
Ms. Schmelzer, real quick,
Yeah.
those are our dominant three zones though, right? So you wouldn't expect it to be in Serpentine or limited development because we have very limited zones of those capacities.
Right, there's not a lot of land in the Serpentine zone,
That's my
right?
point.
That is a very small
Everything's
zone.
in EFU, woodlot resource,
Right.
or RR.
So, just hope I didn't miss something here. I did. Again, I'm so sorry that it's me, a tech guy here. Okay, so the next thing we looked at was basically the stats on where are people that apply for these lots and actually get the license from the state. Where are they being located? What zones are they in? And do they live here or do they live outside of the area? And basically what we found was in the RR5 zone and EF zone, we were finding that sometimes about 50% of the license holders actually do not even live in Josephine County. So we were seeing a mix of people that actually own the land and then a lot of people that were just investing in the land but did not live here. Just going to move on to the purpose of the rural residential zone. The purpose of the rural residential zone is to preserve the rural character of the county while providing areas for rural residential living. And the zone provides for a classification for lands already committed to residential development. I bring that up to you because the charge was primarily looking at that rural residential zone. And when we look at the rural residential zone and the intent based on this, it is to keep the land residential. So that we kept that in mind as we proceeded to create the draft amendments that we're going to be discussing. So the proposed amendments, we have some that will apply to all zones. They are fencing, lighting, plant setbacks, camping, soil runoff enforcement, and definitions. And then we have some proposed text amendments we're going to talk about that apply just to the residential zones, and those are plant setbacks, dwelling first, impervious surface limits, odor, waste, and noise. So with that, I'm going to get started with the ones that would be allowed in all zones. So first of all, we're going to talk about fences. So the state, OLCC, currently started out by requiring an 8-foot high fence for security reasons. With that, we began to see all the tarps popping up, some wooden fences. They now have amended it to allow chain link fences, but that's a very recent amendment. For most of 2016, the requirement was a site obscuring fence. See, building code says that if you have a site obscuring fence over 7 feet, it needs a permit and must be engineered. Current county code says if you have a site obscuring fence over 7 feet, it requires a permit and it must meet setbacks. Basically, typically what that means is 10 feet from the side property line. We're proposing 4 additions, which you have read, and they are: 1, that the fence be a solid muted earth tone color. There are waivers available for that. No temporary materials. That is how we can hopefully get rid of the tarps, the stacked junk cars, things of that nature. If there's a vegetative canopy, it has to be confined to the property it's located on. And then we would also say no more temporary shade cloths unless you're on a grandfathered medical marijuana grow. In order to accomplish this, we also have to tweak some definitions of junk and junkyard.
Can you explain why the medical marijuana grow is kind of exempt?
When we were looking at the rules, the medical marijuana program was almost 20 years old, and we realized that there was quite a substantial investment and buy-in already on the grandfathered medical marijuana. The program had been around. We had substantial farms already out there. It had appeared to be pretty well accepted by the community. So throughout these, you're going to see grandfathering provisions for the medical marijuana because they had that vested interest, so to speak, for operating for almost 20 years.
So there's no state law precluding or enforcing a right on medical from a fence standpoint?
No, there's not. As a matter of fact, I might add, too, that these rules were actually reviewed by the OMMP attorney and the OLCC attorney, as well as Department of Ag, DLCD, and some of the other attorneys as well. The other thing that applies in all zones is plant setbacks from the road. Currently, we do not have plant setbacks. We do have setbacks for fences to protect the vision clearance triangle. The proposed code purpose would be to get the plants further from the road to lessen safety concerns, address visual complaints, minimize fence violations of height and vision clearance, support the comprehensive plan goal purpose of the rural residential zone of orderly development. And because there was town hall comments, I can remember one in particular where the gentleman stood up and said, I want to be able to look out my backyard at my own plants. So based on that, we thought, well, allow the plants, but allow them in the backyard, or to be far enough away from the road, where we would reduce the temptation basically to drive by and pull out plants, or some of those things that we had heard concerns on. Exemptions, it would not be applicable to the grandfathered medical. And then in the residential zones, what it would say is no plant could be allowed within 100 feet of the road right of way, unless it can be in line with setback of adjacent homes from the right of way. And what that means is currently we allow homes have to be set back a certain distance, but sometimes if they're less than the required, you can average that distance to get all the homes in a line down the road. We would allow the same thing for the plants. So if you can't meet a 100-foot setback, you can at least try and get them all in line with the homes that are out there. So it's 100 feet or that average.
Who establishes the first, if you're going to say I'm going to put them all in line, so a guy goes to 50 feet, then everybody can go to 50 feet. Who establishes that first?
So that average distance would be of the homes. So if there's a home out there that's 50 feet, and another home that's, say, 30 feet, that new setback would be 50 and 30 divided by 2.
4.
Would become the average setback, right? So it's 100 feet or the average. And in non-residential zones, the setback would be the same as it would be for an agricultural building, which is 30 or 35. The difference in that being those zones tend to be further away from homes, they're further out there, they're more agriculture in nature. Plant setbacks from the side. The current code does not have plant setbacks. It does have setbacks for structures. Egg buildings have to be 30 feet back. Egg buildings typically have odors associated with them, sometimes crops associated with them. So the goal was to have the plant setbacks be the same as the egg building, which is 30 feet from the side property line. So basically, new in the canopy of a mature marijuana plant would be 30 feet from the property line. Now it does, again, exempt the grandfathered medical. It also grandfathers existing recreational, those that had their permits and licenses and proceeded in good faith this first year. And then it also exempts those of personal use, when you can have the 4 plants, etc. So, and that again is measured from the canopy of the plant, not the base of the plant. Like I said, the camping compounds became quite an issue. We did propose some amendments in the original draft that went to the Plan Commission. The state had some concerns about that. So what happened is we just withdrew the whole thing and said, let's address camping, the majority of the camping regulations when we look at housing. We know we have some housing amendments that we have to bring forward in the future. So we thought we would just bring those forward at that time. What we do have, though, is the current code does look at camping. In a residential zone, you can camp up to 4 months. In a 12-year period, in a resource zone, you can do 1 month. Like I said, originally we had a staff proposal to amend that, and the state came and said, Josephine County, you're doing this all wrong in these non-resource zones. It's not 4 months, it's 1 month period. So we said, that's when we said, okay, let's take a step back on the camping, some of these camping rules, and bring them forward after we had more time to look at them. What we do propose, though, is that for now, amend the code to clarify that camping in a farm and forest zone is 30 days only instead of the 4 months as we have written in the code right now. And then also to prohibit camping under the occupancy section, which I'll get into in a little bit, okay? And then that also means we have to do some amendments to the definitions of camping, camping party, and camping stay. And like I said, you've received all those and the explanations of why. Soil runoff became something of interest. A lot of farms, not all of them, may require soil to be brought in and to be brought back out with every crop. The current code regulates soil runoff on slopes greater than 15%. So this proposal would just be clarified that if there's more than 10 cubic yards of runoff has to be contained at the site, require best management practices. It has to be graded and seeded within 30 days, and if more than 15, if on a slope of greater than 15%, they would require the stormwater management plan like we currently do. Talk a little bit about enforcement. Again, enforcement was something that was set out in that the Zoning and Enabling Act back in the 20s. It basically says that you need some mechanism to enforce the zoning rules that you're creating. So I just wanted to share that with you. What does Oregon allow? And I'm going to go through, spend a little bit of time here on the whole enforcement section because it has really been addressed in some of these letters. What does Oregon allow? ORS 153 allows counties to establish violation rules and fines and issue citations. It allows counties to also impose other penalties in addition to the fine, such as seeking compliance. It sets maximum fines. In this case, these would be zoning violations are Class B violations, so they would have maximum fine $130 to $1,000. It allows for a process to collect those fines. Josephine's proposal is not to utilize law enforcement or the district attorney. The fine would be collected by the code enforcement administrator. It allows for a code enforcement official, which is not proposed. Josephine County currently has a code enforcement administrator, and I went back in the records 2 decades, and we've had the code enforcement administrator at least 2 decades. I'm not sure how long it predates that, but we've had that person on staff that long. It is that person that would be issuing and collecting those citations. So just a little bit about why we feel it's important to have a citation ordinance. And I just want to clarify, there's people out there that say we are doing this just for marijuana. That is not true. As a matter of fact, the violations that we have are violations of the Rural Land Development Code. So what we're seeing are problems with sometimes junk cars, usually compounds. Because the directive allowed us to look at everything and how we would address everything, the issue of citations fell into play when we were looking at these amendments. It's not specific to marijuana. It is an amendment to the entire Josephine County Rural Land Development Code. So when you're issuing citations, it would be for anything in that code, not just marijuana-related violations.
So, Ms. Schmelzer, specifically on this one, and just because I'm asking questions doesn't mean you guys can't, during the report, you don't have to. It's 52 slides, it'd be tough to remember. But just a wrecking yard, so what about people, I almost think I know.
Excuse me, can you speak up? There's people that are hard of hearing over here.
Sure. I almost think I know where that picture was taken, and that person, I thought, was an at-home mechanic. So what about the, not a wrecking yard per se, but somebody who has a home occupation permit for that kind of a process?
If they have a permit, they would not be in violation. One of the problems we have is oftentimes you'll contact somebody and explain to them the rules, and I'll go through the process here, but we tend to get ignored a lot on these, and we tend to get a lot of complaints from neighbors. And if you look back at, again, the purpose of zoning and what it's there to protect, we have to start doing something about it. We just don't have the mechanism right now to effectively enforce our codes, or we do not feel we do it in an efficient manner. And I'll walk through that process, and hopefully you can understand a little better on that.
If this guy were to take those cars and put them behind a fence so they couldn't be seen from the road, does that apply? I fall into this thing because I'm a car guy, and I don't, I have a ton of unlicensed that don't run cars with no engines in them, and they're valuable to me, but they may be an eyesore to.
Your wife? Oh, just.
She said you up to pay your rent. But anyway, I would fall into that. So if this gentleman, is it a site issue? Or, because this right here, 5 unlicensed vehicles not running in condition, I've got that. I've got that easily. But I'm in an industrial zone here in the city, but I'm thinking out there, if he were to shield that from view, is this complaint driven? Is this complaint driven, or are we driving around taking a look at that saying, I'm going to bust you?
No, we are complaint driven. We do not have time to drive around looking for them, but we are complaint driven. And the reason why I bring this slide up is because one of the things I read in the paper or online was talking about how Josephine County was, if they had citation authority, was going to go after everyone who had a junk car in their front yard. That is not true. There's a certain threshold at what point it becomes a violation, and that is the 5 vehicles. In this situation, the person would either need some type of permit for it. If they can't get that permit, then they would have to remove them. License them would be another option. There's ways to meet the code that are actually quite simple if people would just respond to the letters. So in this particular case, like I said, it's the 5 unlicensed that is triggering some of these violations.
I don't, let me quote vehicular code, but I can't license. I have a 65 GTO that doesn't have an engine transmission. It's not insured. So therefore I can't license it. I can register it and I can title it, but I can't license it.
Sure.
So I don't know whether, I'm just, we're not on that subject. I'm sorry,
Yeah.
I wandered around a little bit.
And before you move
We'll talk
on,
about
sure.
it.
So there was a reference to not being able to hear very well, and that's just a general problem with me because I don't speak up that loud, and sometimes I don't have something worth listening to. But there is hearing assisted devices over here. So if anybody kind of is just struggling and really wants to hear what we're saying, there's an opportunity to maybe remedy that over here. So just come and check one of those out. Sorry. Go ahead.
Julie, I believe my question is there an alternative to removing the cars, licensing the cars? Is there an alternative that this guy could do? Basically, could he fence it or not? I guess.
He could put it inside a building.
Beg your pardon?
He could put it inside of a building.
Okay.
Right. It is something, I'll be honest with you, when I started working with this code in June, there's a lot of areas for improvement in this code. And looking at that section may very well be one of them. If you put it behind a solid fence, some Sometimes codes will say if it's behind a solid fence, then they don't regulate it. But at the current time, the code doesn't allow for that provision. So other things that tend to be a real issue for us are the compound. And they tend to start out small, and they tend to really grow. Here's one where we have 9 camping units on the property. We've been after this for over 6 months. We received a lot of complaints on this one, as we do on other ones, and I see some familiar faces here today which may comment on some of the compounds they're having to deal with, but it really becomes an issue. This is part of a compound. This is a single-family home that is being built onto a camper. It has to be removed because it doesn't meet code. You can't do it, but it doesn't meet building safety code either. Then there's other things. In some of these compounds, you start seeing, illegal furnaces, things of that, which actually make a whole safety or fire issue for the entire compound. We end up having a lot of associated problems. This is more of a tent or tarpaulin compound, but what we end up seeing are septic, no provision for safe water, devaluing neighboring properties. A lot of times we get complaints on these where the occupants are stealing property from the neighbors. We know several of these the police have been out to repeatedly, so they really do become an issue for us, and it's probably, I have to tell you, it's the biggest issue we have that really pushes us to really want that citation ordinance, because these are the ones where we get a lot of complaints and we just don't get cooperation on them. We have another one, landowner X. He has over 24 properties. He was in July. We talked to him about the violations associated. He said he wouldn't do it again. He continued to acquire property, lease it out, and we have numerous violations on the leased properties. They just tend to ignore us after a certain period of time. Regionally, I just want to let you know what other counties do. So I looked at our neighbors. Douglas has an enforcement section that applies to the entire county code, not just their zoning code. Their fines are $500 for non-continuing offense, $1,000 for continuing. Their building code has a code enforcement agency, which is under the building official that issues citations. They also allow the director to issue citations for violations of the land use code. Both are considered code enforcement officials. Jackson has it under their county code. They use what we call a code enforcement officer to issue the citations. And then, of course, building and land use have their own code enforcement division that uses citation authority that is granted to them under the general code. We are not proposing that the citation authority be applicable to the general code. It would be applicable only to the rural land development code.
May I ask a question on this? Citations don't force compliance. Josephine County's courts, for instance, have the highest non-compliance and payment in the state, and or one of them. They also issue some of the highest fees in the state, so it can go hand in hand. Issuing a citation, if somebody doesn't pay that to the code enforcement administrator, what then?
Then it goes to Wally's office. So then our legal department takes over, and to be honest with you, it would probably end up being a lien on the property.
Okay.
Then it comes to us, and we move that process forward to go.
So enforcement in all zones, current code, not in the code. Internal policy is that we give 3 tries before we refer it to the legal department. Legal action is optional, and I'll walk through that entire process with you, because like Commissioner Hare said, once we refer it to legal, then legal brings it to the Board of Commissioners, and the Board of Commissioners has the final say whether we proceed with that legal action or not. The proposed code has the enforcement section, which you've read. It does give citation authority. It is consistent with state statutes. It creates an option to create a compliance plan, and it makes citation option available after 2 tries. So this is the current policy. Current policy is you get a 30-day note. We find somebody reports a violation. We go out there and definitely the violations. We give you a 30-day notice. During that time, we do offer an opportunity for a compliance plan. Typically, they're 90-day compliance plans, but we try to work with people because some of these just have so much going on there that they cannot accomplish it in 30 days. So we try to work with them and do a compliance plan. If we don't get any answer after the 30 days, we proceed with a 15-day notice. If we get no answer, we then follow up with a 7-day notice, informing the landowner that if not resolved after the 7 days, the matter may be referred to the legal department. When referred to legal, it then goes to the Board of Commissioners, and then the legal processes it if the board agrees to proceed with it, and then oftentimes it may end up going to court. With the proposed citation ability and the way it's written, it prescribes and requires a 30-day notice, and then it would be a 15-day notice, and then a letter with the citation. Once you issue that citation, they have another 30 days to comply before it's referred to the following process that we did before, which is the Board of Commissioners, legal, and then the courts. So what it does is, currently we don't have to give anybody any notice. We do it as an internal policy. With this, it would be written in the code that we have to give them a 30-day notice. We have to give them a 15-day notice, and then we have to follow up with a 30-day notice when we issue that citation. Past proposals versus the current proposal, we hear a lot that we've tried doing this before, get the message the public doesn't want this. This is not the same thing. In the past, it was proposed that there be a hearings officer. The proposal would utilize the existing code enforcement administrator that is in the community development department. In the past, it applied to the entire county code. The proposal applies only to the rural land development code and what's in it. In the past, that person, the hearings officer, may issue warning notice. In the proposed, we must issue 2 warning notices. In the past, there was citation authority. In the proposed, we have citation authority. In the past, there would be no further notice required. In the proposed, we must issue another 30-day notice once that citation is issued. In the past, it goes to court. In the proposed, it would go to legal. The past proposal that was defeated, the fines were per day for a maximum of $10,000. In other words, every day that you saw that violation constituted a separate offense. Under the proposed, it is not a per day, it's a one-time fine for a maximum of $1,000. It's $130 to $1,000.
So, if you don't comply and you go through the whole thing and you get the citation and you come in and pay it, but you don't do any of the above,
They still have to comply.
then they still have to
They still
comply.
have to comply.
But if a fine didn't do it for them, what enforcement do we have? I mean,
The fine is basic, I'll be honest with you, the fine is basically a carrot. So all these fears out there that we're going to be issuing 1 million citations and we're going up and down the street issuing citations, it's really the carrot to say, you know what, we've given you so many opportunities to comply, our next thing is a citation. And you know what, be advised you're going to get that citation and you're still going to have to comply. It usually, history shows, and in talking to the other counties, it gets people to comply. Once they start realizing they're facing a potential fine, they start working with you.
I think from my perspective, it also saved the board if you did get compliance from spending a lot of time and energy going to court. If they don't after the citation, and we go to court, I think we have a few of those. And we try not to. I mean, we don't really have the resources to pay people. But usually it's a pretty substantial violation. Health and safety is the big one that we pursue. You take this opportunity to silence your phone. Sure appreciate that.
Okay, now we're going to go into those that are specific, those text amendments that would be specific to the rural residential zone. Plant setbacks, we talked a little bit about before. So in the RR1, RR2.5, and RR5 zone for lots less than 2.5 acres, personal use and grandfathered medical basically are grandfathered in and would have that 10-foot side yard, 25-foot rear yard setback. For all RR5 greater than 2.5, the plant when mature has to be 30 feet from the side property line. In all other zones, such as the non-resource zones, the setback would also be 30 feet from the side property line. When we talk about dwelling first, and we're going to talk about that, when we looked at these zones, when we looked at the Lux licenses, which were the ones for the recreational plants, we started seeing a lot of the grows or a lot of the licensees were out-of-towners not living on the property. we received a lot of complaints that people are not vested in their community and therefore they're having the dogs run and transients and things of this nature. So we knew it was something we had to look at. So in the, again, rural residential specific, it says that, and again, it exempts the grandfather medical, but a dwelling must be on the lot first. There are waivers available. And that waiver would be for if you have an RR5 lot greater than 2.5 acres. If one of your other lots has a dwelling on it, then we can give you a waiver. Otherwise, you must have a dwelling on that lot. Camping is prohibited if a waiver is given. So that's one of our ways to make sure we can hopefully try and minimize some of the compounds that are creeping up out there. We also looked at accessory structures. And basically, we currently allow a number of accessory structures. You can have them up to a certain size. You've probably read that. But one thing we don't look at right now are impervious surfaces. Impervious surfaces are those that don't absorb the rain. So what we want to do is minimize the amount of hard surfaces on a lot to prevent runoff onto neighboring properties and to prevent overcrowding. So there's an impervious surface provision in here that it cannot exceed 50% of the lot. Odor was something that a lot of people wanted us to regulate the plants. We really couldn't find a way to regulate the plant odor that's outside unless you had great setbacks, and we don't even know if that would have accomplished it. But what we did do was look at some of the other county ordinances that are out there. They do have regulations on indoor grow areas where they would require an odor mitigation system like a scrubber. So what this says is indoor grows on RR5 lots greater than 2.5, you would actually have to have an odor mitigation system. As far as waste, the state does regulate waste, the compost. And what we're saying is in the smaller residential zones, if you have a compost pile more than 100 square feet, it has to be stored and secured in a waste receptacle or composting bin. As far as noise, for all residential districts, other than a fan for odor mitigation, there shall be no mechanically generated noise associated with production or processing of marijuana, audible from adjacent properties 1 hour after sunset nor prior to sunrise. Now before I go further, I just have to let you know, when the Plan Commission discussed the proposals that we just talked about, probably the biggest one that had opposition was the citation one. The other ones, such as the lighting and some of these other ones that we went through, I missed the lighting side. There is a lighting one that says no lighting shall be emitted from accessory buildings as seen from adjacent properties, but you probably read that in the proposal that you have before you. But we really didn't receive complaints. The biggest complaint was focused on the citations. It didn't address the lighting. We really didn't hear, I can't remember hearing any opposition to the odor. The complaints were focused on that citation ordinance. The Planning Commission actually went back and forth when they reviewed those proposed amendments. And basically they couldn't come up with they came up with different recommendations and then finally said, you know what, let's just forward this with no recommendation. They couldn't reach a consensus on what to send forward to you. So those were the ones that were applied to all or specific to the rural residential. One of the other amendments that came up was related to the Williams CAC. And what that is in our county we have certain areas. At one time we had 8, we're down to 1 CAC, Community Advisory Committee, and Citizen Advisory Committee. And basically what a Citizen Advisory Committee is they kind of are a watchdog on planning matters. They interact with the planning department and give input on planning matters. So we only have 1 right now, and that's in Williams. And they actually said, you know, we do want to work with you on the marijuana regulations. We would like to see some amendments that would give us more ability to review these. So that's the gist of pretty much what the Williams CAC proposal was. And you've read that in your letter. So it talks about the process that they're asking. Basically, they want time to review the applications, time to comment on them. Staff has no issue at all with working with them on that if that is proposed. One of the other things they did is they said, you know, in the future, we'd like to start looking at rules specific to Williams. And so we talked about creating an overlay for them. So what this proposal does is it also creates an overlay which doesn't really have any rules in it yet, but by creating the overlay, you're saying, yes, we're willing to accept that you want to have some own rules for your committee, and if this is passed, then they will go forth and develop their own rules, which will then come back as text amendments for us to review at a later date. But by actually creating the overlay section, it gives them the okay to proceed with working on special rules for Williams.
What's the makeup of the CAC? Is
It's
there 15 members, 20 members?
It's actually a 5-member board. There's state statutes that govern them. There's actually a county code that governs them. They have to have bylaws and they have to follow the same open meeting laws that we do. So it's a very formal process actually. They are, like I said, they're the only CAC we have right now. We interact with them on a weekly basis. So from a staffing point, I think it's good to accommodate them. It's good to see citizens actually want to work with us and have something specific to their area.
They're an advisory committee,
They're advisory.
correct? You're not transferring
Correct.
authority to them to say, well, no, we want it this way, or whatever. They have to come back to you and to the board.
Correct. They are merely advisory, but I will say this, it's nice to have somebody giving us input on issues because we don't always know what's going on out there. So it's kind of like having the pulse in the neighborhood to work with. So that is another part of this proposed text amendments that
There may come up at times opportunities where you'd like to weigh in on these things and apologize for our structure, but there really isn't an opportunity to do that other than the 5 minutes that you'll be provided after Ms. Schmelzer's done and the board is done. This is really our time with the planning staff, and then we'll get to you. So apologize, but you might have to just jot it down. You can provide clarification afterward.
And is there a mechanism for somebody that doesn't, so this 5-member board says, yeah, these are the rules that we want to live by in Williams. Is there a mechanism where somebody says, I don't want to live by those rules because of?
Absolutely, and that's why it goes to a public hearing. So they come up with the rules they want to have in their CAC, and then it comes back to us just like today, where we have the Plan Commission has a public hearing on it. Depending what's in there, it might also come to the board for approval, depending what zones they propose it to apply to. And just a little bit on that, state statutes say if your proposal affects resource zones, then it also requires board approval. If it just affects, let's say, residential zones, then it would just take planning commission approval. But yes, there are proposals that they come up with. Like I said, this would give them the framework to actually start working on those and bring some proposals forward. I've already told them that when they do have their proposals, I would run them past DLCD and some of the other attorneys, public works, etc., to see what can be legally put in there, and then it'll come through the entire public hearing process just like today. Some of the things that have come up that have not been addressed in the proposed text amendments one was canopy limits. The state allowed us to limit that to 40,000. At the time, we felt it was best not to touch that, give it a first year and kind of see how things have been going. The state changed some rules that we're actually seeing canopies greater than 40,000, but at this time we don't have any amendments to that effect. We do have a lot of issues with tree removal and invasive species that we've said not to do through the Rural Land Development Code and leave it up to the Department of Ag and Forestry. Complaints about dirt on roads, those concerns were forwarded to Public Works, but there's nothing in our code about that. Water, again, people wanted to see us do more with the water. We felt it was best to leave it up to DSL because they are the ones that do work with the water rights. Access, parking, and traffic, had a lot of complaints on that. Properties do have to have a legal access. We do regulate gates, so that is pretty well addressed already. A lot of concerns about guns and dogs. Hopefully some of the proposals we have will help alleviate that, especially if we can crack down on the compounds, and especially if we can stop or requiring occupancy in those RR5 grows. And then there's a lot of complaints about law enforcement, and as you know, there's nothing the RLDC can do about that.
On discharging firearms, I would think if you're got pretty close proximity to neighbors, is there something about
Not in the county code.
endangering or anything? Nothing?
You can't shoot towards someone's house, but otherwise you can shoot in the county.
Well, then it's something that we can't address through this. So, Okay, I just want to go through the letters. We're wrapping up here, okay, so just bear with me. So I just want to go through the letters that were received. So the letters, I received a few, and then the ones that were sent to you, some of the ones that were forwarded to me, I also have those to summarize. So I'm going to go through and summarize those for the record real quick. Okay. I object to the proposed changes of the amendments that allow marijuana grows on rural residential land. The county has a large percentage of land zoned RR5, and allowing legal grow sites on residential land will significantly impact neighbors and neighborhoods. Commercial marijuana grows should be on farm-zoned lands, agricultural lands. It goes on to talk about groundwater, herbicides and pesticides, fencing, and then just a concluding statement that they believe approving commercial marijuana grow sites is not compatible with a residential home, and that is from Gene Mount. And then we have, I support the new text amendments that address growing marijuana in the residential zones, including giving the planning director the authority to enforce the rules, and that is from Helen Early. And then we have, I 100% agree with the proposed changes. In addition, I stand behind the director and the work she has done and continues to do for Josephine County, and that's Phil Selfin. And then we have one with two specific concerns. One is water and wells, and they feel that the county does have authority to address that. And then the other concern regards enforcement. It talks about how the code talks about alleged violations and the fact that it appears that people could be penalized without being proven guilty. And then they remind you of previous efforts at the citation ordinance, and that's from Malcolm Drake. Then we have one, as retired people living next to a pot farm, we have nowhere to turn for help. The state doesn't care about our plight, nor does our state rep. We hope you will create regulations with Keith. They talk about the environmental damage. State pot regulators told us they don't really have any rules. Check with your county government. From what we have seen, it doesn't look like the county is going to have any regulations with Keith. We are left hanging slowly, twisting in the wind. And that is from Stephen Florence Shepard. And then we have, please repeal the recently passed voluntary code compliance certification ordinance, and that's by Ricky Brown. And I'm not even going to comment on that because that's not subject of this hearing at all. That was something that was adopted before you took seat with the county. Then there is Margaret Goodwin, who is the chair of the Plan Commission. In the interest of trust of transparency, I strongly urge that you plan to adopt any new text amendments on matters that were previously rejected in a referendum. It would be highly beneficial to hold a separate, well-publicized hearing dedicated to those text amendments, and that's Margaret Goodwin. And then we have the greatest downfall of civilized societies is their repealed failure to recognize or acknowledge the importance of their forested land to their water supply and their farmland to their food supply, and their ability to independently to provide for their own survival until it's too late. And they talk about greed and degradation and water rights. That's Nina Horsley. We have another one, talks about amendments for a hearings officer. Just so you know, that is not part of this public hearing. We will have an upcoming public hearing on a hearings officer, but it's not part of this, so I'll skip past that. The letter also talks about the vote opposed code enforcement, giving the community development director citation authority as a code enforcement administrator is essentially the same thing as and is as equally appalling. It goes on to talk about some concerns she has about the way that the section is written and some things that she feels are not legal. And that is by Sandy Casanelli. And then we have a very long one, which I'm not going to read. It's 10 pages and then has a 4-page attachment. It's from Ray Smith. You have received that, so I won't go into the detail on that. Just real quick, I believe these proposals to be woefully inadequate to address the impacts and conflicts that have arisen from the unregulated rush to transform the rural residential properties. Goes on to suggest some amendments regarding odor mitigation and several other things. And then we have John Chambers, who is a member of our Plan Commission, submitted basically his comments and his dialogue that he had presented to the Plan Commission. I won't go through that either. That's a 9-page letter. But just real quickly, he did talk about Measure 91 prohibition, state regulation, education on medicinal purposes, and new industry, odor, lighting, things of that nature. So,
And the last paragraph wrapped it up.
and the last paragraph says, I recommend the amendments as proposed with some modification restricting total acreage. And again, that was John Chambers. So those were the letters that had been forwarded to me or that I had received. And with that, I'm done.
The board received one additional one. I received it, I guess it was just this morning, at 8:07 from Linda Nadal. Linda J. Nadal. But otherwise, I really appreciate people taking the avenue of not necessarily needing to be here today to be able to provide testimony to the board. It's kind of nice to have the record, right there to reference people's letters in total context. So taking advantage of that is a good thing in my mind. Any other questions?
One question that was presented to me was regarding flood zones, where currently, if I want to build a structure in a flood zone, I have to get permitting, or there's certain exemptions and all that. How does that work to structures for agricultural use in the flood zone?
Okay. So the flood zone is regulated by the federal government, and we adopt the floodplain zoning ordinance. Just so people understand, when a county adopts a floodplain zoning ordinance, what that means is their residents are then eligible to apply for flood insurance. If we did not, our residents would not be able to apply for flood insurance. So what it does when it comes to agricultural buildings, some buildings end up being exempt depending how they are built. When it comes to marijuana plants in general, if they are involving fill, which many of them are, they tend to be a little pod or pack, that ends up being fill and actually cannot be put in a floodplain until they obtain floodplain approval. Floodplain approval is a process they go through where they need elevations and they need to show what we call a no-rise study, which shows that the building they're putting in there or the fill they're putting in there won't alter the water levels in the event of a flood.
So in the current process of, I guess there's two different processes for both medicinal and recreational and such, but through the permitting process through LCC, is there a process through your department before a permit is received from the state?
No, the only process is that LUX, that form that says that use is allowed in that zone, but it doesn't say that they're going to get permits or anything to that effect. So it doesn't look at floodplain or anything at that point. What happens is the state, through the OMMP program and the OLCC program, is they issue their licenses. That I'll be honest with you, there's very little interaction between agencies and counties at this time when they issue those. One of the problems we have right now is oftentimes, I shouldn't say often, but sometimes we find where people are operating without permits. I can think of one offhand where we've been after them to get their permit and they haven't. So that's the type of thing where it'd be nice if OLCC would check to see if they have permits first or follow up and see if they can get permits. But that's not part of the OLCC or the OMMP review process at this time.
And are you aware of any of the proposed amendment changes at the state level that are before the legislature this session?
Yes, I am.
And have those had any bearing on any of the recommendations or proposals?
No, as a matter of fact, I talked with the attorney for OMMP for quite a while when the Plan Commission was meeting, because people were talking about all these great changes that were coming and we just really need to hold off. And we couldn't find anything that was so substantial that should say a county should just hold off and put everything on hold for regulation. I'm also aware of some that are being proposed outside of OLCC and OMMP that are just proposals being brought forward by representatives or other people at AOC, and none of them, I would have to say none of them affect what you see today.
So one of the things that was suggested was that the county does have some say in water. So for somebody who's wanting to abide by all the rules and do everything above board, and they come before the planning department to get a permit, Is that something that you have them produce as far as water rights or what water accessibility before permits are issued?
So the way the code is written right now is if somebody wants to build a house, for example, they have to, the code says you have to show proof of water rights and that you can have water. There's nothing in the code that says in order to have a marijuana grow or any crop that you have to show proof of water rights.
And then, so that I don't hog all my cohorts here time, going back to the compound, I've been on several in this county, and I'm just curious, as you get complaints currently, DEQ is the authority when it comes to any waste management in the rural lands. So as far as a need for enforcement at the county level, I'm not sure that we need that. Even as you stated, it is a DEQ issue, but are those currently being referred to DEQ when you're hearing of compounds that are just digging a hole and kind of scooting along? No pun intended.
So originally, we would refer those complaints to DEQ, and DEQ said, we're not going to act on them if they come from you, they have to come from the landowner directly. So now we have to refer the landowners directly to DEQ to file a complaint.
On the composting aspect, is that, are you talking about the byproduct of growing cannabis?
Yes.
That's what you're composting, you're gonna take everything you have left over and
Correct.
put it in a hole or something, or whatever you do. Good, thank you.
One more question. Repeat violators. I mean, is there, I mean, at this point, maximum fine is $1,000, and then from there, you potentially go through the process of going through court. So they get the property cleaned up, they pay the fine, everything's well and good, and then it kind of goes back. Do they start from scratch? Or, okay. Or if they're found by the courts, even in that process, and still don't clean up, what happens then?
If they go through the whole legal process and they're still not cleaning it up, they would need a court order from a judge. And if they don't comply with it, then there's different avenues we can take. One is the lien on the property. One is for the county to come in and clean it up and actually try and recoup those costs for lien on the property.
And that we do in partnership with the Solid Waste Agency?
The Solid Waste Agency, or Environmental Health, basically goes after rubbish on property. And they will not inspect rubbish on property unless there's 3 complaints filed.
Any distance from the ground zero, in other words, they ask people, the complaints have to come in, say, within 1,000 feet or something, or it could just be somebody driving by?
You know, that's a really good question. I believe it's 1 mile, but I'm not, I don't know that for sure. That is actually handled by a different department. But I know it does take 3 complaints in order to follow up on a rubbish violation.
Thank you.
I don't know the answer to that either, but I think you're right along those lines. There is a product distance restriction in the Solid Waste Agency. Okay, well, you didn't lie when you said it was going to take you about an hour to get through all that. That was minus our questions. So I had predicted a time for a break at about 10:30. Leave it up to this board as to whether or not you want to start with the next section, which would be comments from citizens if there are no more questions of us. This would be the next draft or next phase of this hearing process. Really, that's kind of why we wanted to do this, was to hear from you guys. So I'm going to encourage your comments to be directed just to the board, not to the public. Also going to encourage you to not be necessarily repetitive. If you can remember the person's name who said basically everything you wanted to say but got there first, you could just say ditto and we'll mark it down as such. This isn't an opportunity to say, well, there's 150 people who are for something and then there's 10 people who are opposed to it, and thus that's the purview of the community at large, and that's how we should go forward. It's really just, one-on-one. Each individual comment is coming in, and that's how we're going to be evaluating that. And I think, as it was said, I don't know that we really have an expectation of coming out of here with a refined piece of text amendment proposal today. This is really just kind of starting from those 4 town halls were really important, I think, for giving direction to a previous commissioner and the planning director when she was first hired. But I didn't attend those, and that was purposeful. This is the structure, in my opinion, of where we're going to get the best opportunity to hear after a proposal's been submitted. Otherwise, it's just kind of out there, and people are speculating on what they'd like to see. So If there's nothing else, you're going to be provided 5 minutes, and that doesn't seem like a lot of time, but there's been examples in my 6 years and over 300 of such hearings where people really do a pretty good job most often if they're prepared to get through everything they need to in even less time. Mr. Sullivan's illustrating 3 minutes at a weekly business session. Land use hearings provide you 5, but you really need to be on point to the subject that's before us today. If it's a different subject, I might have to cut you off a little bit and say, well, that's going to be a subject for another day. We're just really trying to get through the issues that were presented by Ms. Schmelzer and that are before the board. So all you have to do is just raise your hand. There is no left or right. I don't subscribe by that. We're going to start with the gentleman in the back. Please just state your name and general locale of residence for the record. You provided 5 minutes.
Good morning. My name is Shane Kristen. I live in the county, Williams. I appreciate all the work that the planning department has done in talking with legal representatives of other departments. From my experience in dealing with the board, past members, and a little bit of this crew, you seem to rely a lot on your legal counsel for what you can do. I would like to propose to you that you ask your legal counsel what you cannot do. Part of what your planning person said was you wanted to impound runoff from a property. I think that would put you in non-compliance with state water board because you can't impound runoff water. It's against the law. And Mr. Hare, I've come to speak before you a few times, and you have past experience in being associated with cannabis growth. And I really want you to look deeply at the subject of odor. Now, admittedly, there are times of the year where a cannabis plant can produce a great deal of odor. And if there's numbers of them, yes, we have odor. But that's only a limited time of the year. I've asked the board before to delineate where those complaints of smell are coming from. Now, if we only have 2 months that this plant is being offensive, what about those other months that people are complaining about? My impression is that people are complaining about the use, the smoke, the smell. I don't think you can regulate that. My best advice would be to require dark sky lighting so that neighbors aren't offended and I get to see stars. And what disturbs me is every year when they flip the switch, I see a fire truck head in that direction because somebody calls and says there's a fire. Some of those lights are pretty orange. And I feel that's a waste of resources. If we could have dark sky lighting where the light would not emit anywhere off of the property, we could eliminate that problem. I think there needs to be a neighborhood involvement in granting a permit where, for instance, we have a problem in Williams. I think it's going to be rectified. The last CAC meeting, the 2 opposing parties were in conversation. And if there was a process where growers could be encouraged, if they're going to use large greenhouses, to have fans that emit sound in a low decibel level. We could take care of a lot of the complaints of noise. I've been involved in the medical community here in this county for 10 years. I've been appealing to you for about 2. I also ran against these 2 folks up here, you know. I appreciate, again, your service to the people. This is a difficult job. Mr. Deanna told me, if you get this job, they're going to hate you.
Half. Only half.
Only half. Is that my time?
That was. You sure covered a lot of subjects. I think you're a pretty good example of what can be conveyed in 5 minutes.
On a last note, sir,
Real quick.
I would ask that you separate the CAC for Williams out of this proposal so it can be handled on a different agenda. Great. Thank you very much.
So when you're given 3 minutes at some of our weekly business sessions, I'll kind of give you 30 seconds after. 5 minutes, I'm going to cut you off right at 5 because we've got a lot of people and we'll be here till next week. If we give everybody another 30 seconds, which graduates into a lot more than that. So in the front row, Mr. Carhart. Try to get the most important subject first.
My name is Stephen Williams. I'm a resident of Williams and a member of the Williams CAC. I'm going to read this. We are sure it can be quite wearing for you when proposals appear before you, and the public brings strong emotions, accusations, and heated controversy. The hearing can be very long and quite uncomfortable, and when your decision is made, there will be citizens who are very unhappy and critical. I am sure you often think how great it would be if the citizens who have differing needs and hold very different perspectives could have met earlier with skilled facilitators and found acceptable compromises before a proposal reaches you. The CIC works this way within Williams. We have town meetings to air feelings and perspectives, and then we work towards compromises that all can live with. In order, however, to serve you and our community in this way, we must know with enough lead time what land use issues are coming. We just went through a situation where we did not know what a proposed land use, local land use, until it was about to be permitted. This issue almost broke our community apart, turning longtime friends against friends. Had we known about the situation in advance, we would have been able to mediate the differences of opinion, create workable compromises, and avoid a great deal of community strife. To serve our community best, we need this early notification. This is even more critical when the CAC is being asked for input for the official planning department record. The main gist of what we are asking from you today is advance notice of, and when indicated, a more thorough review process for potentially controversial land applications in our area. We are asking you to separately approve the amendments to Article 12, 20, and 69.5 in order to grant us what we need so we can best carry out the responsibilities that you have given us. Let the CAC do the local groundwork so that when things reach you, they are no longer controversial. We will make your lives easy. We will make your lives easier if you allow us to work efficiently, effectively within our own community to further our mutual goal of preserving a healthy rural lifestyle in Josephine County. I also would like to add that if we do get our overlay structure that we are requesting of you, it must be noted that we are going to be doing extensive vetting and hearings, etc., in our local community. That it's all about community input and community approval. Before we make any kind of moves as far as amendments that we bring to you folks. I do believe that that's critical, that you be aware of that.
Thank you, Mr. Williams. Just want to make a note that if you had a question for staff or the board later, we won't necessarily engage with you immediately, so you're not going to get immediate gratification on that. We'll probably do that at a later date, maybe take a break and such. Gentleman over there on the wall.
Yes, I just wanted to ask.
You actually have to come to the
okay.
podium so that we get you on the record.
Excuse me?
So that we get you on the record as
All
far
right.
as your name, your address, and the issue that you brought before the people.
All right, my name is Al Carter, and I'm from Selma. And all I really wanted to ask was what I've seen on the slideshow, and it could have been directed to this lady, but what is a serpentine zone? And also what, I just want to know what the zoning with caretakers, or there was something on caretakers that I missed. But mostly, what is a serpentine zone and where are those zones located at in Josephine County?
She may be able to get with you later to
Okay.
clarify that. So that's probably my fault. I referenced that as well.
Okay, so I should get,
You should. Yeah, that's a specific question.
and on the caretaking thing goes to her too?
Probably.
Thank you.
Thank you. Mr. Thompson.
Cliff Thompson and Grants Pass. Until this Board of Commissioners takes a serious look at the countywide homeless problem, I think that these compounds should not only be allowed, but they should be appreciated and expanded upon. You know, too often, that's the only place where a lot of these people can go. And to put a 30-day limit on that, I think is wrong. I think this board should address homeless issue, and I think it should be done sooner than later. And I think these property owners, you know, should be appreciated, you know, for taking people in. Otherwise, they may be, you know, on the streets. Our president right now is proposing to build thousands of miles of fences. In Josephine County, I would like to take the opposite approach and tear down these fences. In Josephine County, fencing should be optional and not mandated. And Josephine County Board of Commissioners should use their home rule authority, you know, to find a way to make it optional for growers to have fencing or not. In regards to some of the other things on that slide, Josephine County has always been strong on property rights, and yet a lot of these proposals go against that. If I have a rural property and I want to dig a hole and crap in it, I should be able to. We have, for hundreds of years, did that before we had these DEQ and EPA regulations. So I would take a look at this proposed amendments and rules with that in mind, that, you know, the property rights of Oregon have always been first. That's why we're a home rule charter county, and I would appreciate you taking it from that angle. Thank you.
Leave it to former governor candidate Thomason to raise the issue of, so you may disagree with somebody who comes up. Some people agreed with Mr. Thomason, in some cases I do as well. But you're not allowed in this hearing process to really like applaud or boo. I think it goes both ways. So if people feel
I put a
comfortable
boo on the
coming up,
lap, which I, sorry.
that's perfectly fine.
Well, I had
Your
to
silent one
comment.
in your head is just fine as a place to keep those comments after somebody else's comments. So we won't allow that in here. The woman with her hand up. It's just polite and fair, both ways. Feel free to pull that mic down.
Thank you. Hi, my name is... Pardon me?
This portion will go towards you if you need.
I think I'm good. Can you hear me?
Can.
My name is Susanna, and I am in southeast rural residential Grants Pass.
What was your last name?
Docima.
Josephine.
First of all, ditto. Thank you for addressing the camping fencing. I've been here 22 years, and my 40-year-old adult son and I live together because he has brain injury and is seriously dependent on being able to work at home as well as cultivating medicine for his injury. It's our livelihood and it's our home. It took us years to find a home, rural, residential, because we needed to live someplace where he could walk, because he cannot drive. So to be an independent adult, he can walk to town and see friends and not be completely dependent on me. We have a 2-acre parcel. That's enough for us to grow, and we are fully licensed and compliant and all of that. If it goes to the 2.5 acres, we can't move. We can't afford to move. We would be not only out of business, but out of medicine. And that would be an extreme hardship. We have plenty of land that we're growing a vegetable garden as well as ornamentals and that sort of thing. We don't need more land. In fact, we downsize to this land to be able to grow. So that would, the 2.5 acres, I think, is just not a necessary thing. I have 6 neighbors. 5 of them are extremely supportive of what we do. In fact, 2 of them want me to grow for them, which I don't, but extremely supportive. It seems like the problems that were addressed were basically the camping and fencing, which Cliff addressed, non-resident growers. It seems like there's a lot of stuff all lumped in, but if those are the main issues, then why don't those issues get addressed separately and just not lump it all into marijuana growing and there's all these things that need to be changed? Start with the most pressing issues and work your way down to the less pressing issues and address that. And I did have to get Lux, and I have to say that I did have to show water rights, or not water rights. That is addressed. I did have to prove that, and also I had to prove that I wasn't in a flood zone. So contrary to what was presented, that is being addressed by Lux and the DEQ, and you do have to prove it. And they do come out and inspect and make sure that you are in compliance. So that's about it. Thank you.
I have a quick question. So just by virtue of having to get a Lux, you're not a medical grower, you're a recreational grower.
That's correct.
Okay, I just wanted to clarify.
But just in regards to that, it's all medicine. You can label it recreational. You can label it medical. You can label it whatever you want.
Yeah.
It's medicine.
We're not debating that today. Mr. Hart.
Thank you. For the record, Bob Hart, land use consultant. Here in Southern Oregon, I submitted a written testimony Friday, 10 pages or 11, but I'd like to go over some high points that I think really need to come out, because this whole thing, the devil's in the details. The prohibition in RR1, 2.5, and those less than 5, I think can be mitigated to an extent with the new micro tier 1 limitations that the state has recently put into effect. Indoor grows could be like 625 feet, not much more than a garage. Outdoor grows 2,500 square feet, less than 6% of a 1 acre parcel. So I think that would mitigate some of those issues. In the rural residential zones, there is a setback for agricultural structures, and that was to try and mitigate impacts. And I think that the plant setback to those agricultural setbacks is appropriate, trying to protect it. But in the resource zones, it just takes away area that not necessarily going to be next to houses. So I think the setbacks for plants in the resource zones is not appropriate. The same way I feel about fences in the resource zones. It says that you have to set fences back 30 feet. What that's going to do is bring rise to property line problems in the future, because most people say, well, the property line's along the fence. If you're requiring fences to be set back 30 feet, you're going to have conflicts of where property lines really are in the future as people move away from it. So I think the setback issue on fences really needs to take a lot more work. As far as enforcement, that was a major part of the presentation. I think that needs to be set aside as a separate issue from the marijuana rules and regulations. Because there's a lot of other things that need to come in, like odor control. When you read the details of the report, it's proposed that in all cases an engineer's report be submitted. But there are some standards, I know they adopted them in Jackson County, it seems to be working, of a certain volume and a certain type of system is an acceptable requirement. And if you put it in that way, you don't have to go out and hire another engineer and just drive up the cost. One of the things, it's a minor point, but serpentine zone, it's not a residential zone, and it has the same limitations and restrictions as an actual residential zone. I think it's a non-resource, so there needs to be some accommodation for that. As far as impervious surface, I think this is a solution looking for a problem. I don't think that there's a lot of issues out in the rural area. If this was an urban area where you have approaching 50% impervious surface on a lot, then there would be issues that need to be addressed. But I don't think it needs to be addressed here in the rural area. One last thing on fences. I saw pictures, and I think we need a definition of what a real fence is. And it has to be something that is more substantial than some black plastic. But I don't see in here a definition of a fence. So that needs to be defined. And one of the things, being from Southern Oregon, everybody's pretty independent, and I've seen it happen, especially along the river corridor. When you start talking about paint and certain colors on things mandated in a code, it takes away a real property right that I don't think is necessary here. It's substituting one person's judgment for another, because there's nothing, if you have a real fence, that a certain color would have to be just an overburdened thing. One thing I would ask you to do as you review these things with your legal counsel is to look at the Dolan decision of a takings, and also look at Measure 49, because if you reduce property values by new regulations, the county would be liable for compensation of those property owners. And property values are changing dramatically because of this whole thing. I've got one last thing to say here is the matter before you today is a change that no one could have anticipated just a few years ago. I'm of the opinion that this is a transition period and the industry will evolve over the next few years. As I see the proposed ordinance, there's some major changes that need to be addressed and some minor ones. I just hope you take time. Thank you.
Yep. I think that's what we will do, is take time. Gentlemen in the back. So we're going to take a break right after you get done.
Sure. My name is Riversong. I'm just a simple peasant farmer from
I didn't
Applegate.
hear it, I'm sorry.
My name is Riversong. I'm a peasant farmer in Applegate. So there's a lot here. I'm just going to cut to the chase. I encourage you guys to flex whatever power you can to address the major issues with all appreciation to the people taking care of their land. I know people took care of the land, dug giant holes and used them in landfills for 20 years, and then people buy the land, they have this landfill under their house they didn't even know about. That's all being land use. So a lot of people jumping on the commercial bandwagon who don't know how to grow, don't know how to steward land. Many of them are from the cities, and not all of them, but many are coming from the cities, and they don't know how to use a trash can. They put all their trash in a rural neighborhood, like in Williams. I know 3 houses like that. A bunch of young kids, 15 kids at one site, trash all over the land. Dogs are coming. They blame the neighbors for not taking care of their dogs. They don't even know how to use a trash can. These people need inspectors to come through and help them set up their gardens. No, you can't just dig holes and then not take care of the water and build a proper culvert. You know, half-assed contractors who don't do their jobs correctly and don't make the roads after they put in electrical systems and then the roads flooding out. Contractors nowhere to be seen. The grower doesn't even live there and they're in Hawaii. These are some of the problems I've seen in my neighborhoods. Regular mainstream Joes who want to grow a commercial garden in a neighborhood, big lights, all of a sudden, the culverts are all flooded when the rain comes. They cut off 3/4 of the tree and leave only the branches over the road. So this summer, when everything cranks, those trees are going to fall all over North Applegate Road, which is the main thoroughfare. I told him, hey dude, you cut all these trees, they're falling all over the road. Doesn't care. If you don't make legislature that has teeth, people won't care. $1,000 fine is nothing for major violations. You should fine people if they don't follow the rules. Give them some time to comply, and if they don't, because they don't care about your fine or $10,000 because they're making $250,000, well, good luck. Okay, that environmental impact. The way the water flows on the land, people just don't even know. Next thing you know, the road's flooded over. So that's serious. You need inspectors. You need 3-part inspections. Where you guys charge a fee. If you're going to have a commercial grow in Josephine County, you need to pay a fee. So an inspector will come out, look at the site, say, yeah, this is some ideas on how you should do it. You can put it in this area. Then boom, the inspector comes from the second part and makes sure everything's right. Boom, so you have inspectors, charge a fee, so you pay for the job. Simple, easy sounds, generator quality. People need good generators, not old, broken generators that fill the whole valley with noise. Fans and motors. See, spinning, well, I don't want to talk about that. It's terrible. So 3-stage permanent, I think that's important. You need inspectors to make sure these people are putting in gardens properly. You need inspectors. It's the only way. If you don't give them a permit to grow, they can't grow until they have a permission. Find a way to do that, because there's a percentage of these people that are destroying the land, destroying the waterways, destroying the roads, destroying the neighborhoods, because they don't know any better and there's no one there to tell them. So if you guys can use your power and the Williams CAC, I'm really happy about that. The CAC, I like that. Hope you guys can all work together to help educate people, because they don't know what they're doing. Thank you.
More applause, please. Really, I don't want it to go the other way. It's just not kind even to, I agree as well. So we're going to take a break, and we'll be back here at 10:45. So we're going to reconvene here at 10:48. I would like to say that I just really appreciate, I know this is an emotional issue for a lot of people on both sides of the issue, but I just really appreciate everybody kind of keeping a calm demeanor when they're making a presentation. So far, that's just been really pleasant, and sometimes not always the case in these types of hearings. We're going to get started here. I don't want to belabor the subject, so we're going to go with Mr. Hoke in the back.
Dennis Hope, Fire Chief, Illinois Valley Fire District. I live to the south side of Cave Junction. So I want to address this from both my professional and then as a resident of the Illinois Valley. This enforcement issue goes beyond just the topics we've been talking about. It actually is a public safety issue. Our people, all 2 of them, that deal with public safety and code enforcement need to have the authority to issue citations. I'll give you an example. We've had a paint booth in Cave Junction, a legal paint booth that's been going on for 3 years. It's a hazard to the people that work there, it's a hazard to the neighbors, and it's a hazard to the firefighters that have to respond there if there's a fire. But yet we can't get any movement on this particular structure. And that's a big issue. They need to have that enforcement authority. We respond to numerous incidents in the Illinois Valley. From an enforcement standpoint, the compounds have become the new structure fire for us. We're always going to the compounds for incidents because of illegal wiring, campers that have furnaces in them, wood stoves. They're there for a long period of time. I just saw one last week where they've actually ran the electrical cord to an illegal wire hookup to a creek, which absolutely floored me. I mean, it was a picture-taking moment for us, and that's our next fire. We see the gentleman talked about the dumping of trash. We see it all the time. It was on an incident up in Draper Valley where they cleared 100 acres for a grow, and they had actually a landfill on the property, a huge hole. That particular one was turned to DEQ, and DEQ did fine them $4,000 for that one, based on the pictures that the fire district took. This enforcement issue is significant, and has huge ramifications just beyond what we're talking about today. Gentleman brought up about the grow lights. Every fire district in Josephine County has had to respond to grow lights. It's usually when it's foggy, and we do get a bit of fog here, but that's usually when we get the call, because that light, that orange light, looks like a fire, and I see it, and I understand why they called it, and we're appreciative, but we also want to try to be a little bit educational. If you cut a call while you're down, it is a lot of resources to go to those calls. As a resident, I'm very fortunate to live in the Illinois Valley, and I got to tell you, I think it's the prettiest place in Josephine County and in Southern Oregon. I've lived there for 4 years, moved there from Colorado, and I've watched in 4 years, really the last 2 years, a huge degradation of what's going on in our community, and it does affect my property value. I'm very fortunate to live in a subdivision that has covenants in place, but there's no enforcement of those covenants. And we have a property that they've clear cut, they're dumping sewage, they're dumping trash, multiple campers live on the property, and it has a direct effect on me and the property value in my subdivision. So I applaud the commissioners for taking the time to at least try to address this and come up with a logical way to meet both sides on this issue. And again, just one last point, please look at this enforcement issue and support the planning department and support the people that are in the field. When they issue a citation, back them up. Thank you.
Thanks, right here.
Cheryl Outfleet, 235 Woodrow Way, out in Murphy. My issue is 380 Murphy Creek Road is a compound that borders my property. They've torn down my fence. They run hoses for their sewage onto my property. I have a big sewage pile, trash, trailer right up against my fence with their hoses running under the fence. Cables everywhere. There's 2 trailers, 2 or 3 outbuildings they're living in, a double-wide mobile home on a ½ an acre. This is zoned R5. I have 11 3/4 acres. Thanks to all my neighbors who have to put up with the smell and the noise and everything, I live down a little ways down the hill from my property line. I didn't know this was going on for quite a while. So consequently, there's a lot of sewage on my property. And it just seems like there's something you can do about it. The guy that lives there, doesn't say he lived there, he is brain dead, has been for years. I've lived there for 40 years on this property. And he has lived there and never had a problem. But he is like a ward of the state or something. He doesn't own the property, his sister-in-law owns it. And she lives in Portland and says, I don't want nothing to do with it. Keep the property, do whatever. She doesn't want to deal with it. So anyway, that's, my problem. The smell and the sewage dumping on my property. And they walk through my property, they take things off my property, cut trees off my property for firewood. And I have witnesses to this and pictures. Okay?
That's Mr. Sullivan.
Good morning, everyone. Thank you, commissioners, for being here today. Before I begin, I want to put into evidence a testimony. I have a petition from at least 70 people and counting opposing these regulations, so I want to... So whatever anecdotal stories you might hear, these are 70 people who oppose this. First of all, My main concern in this, that this is a private property rights issue. I want to commend Cliff Thomason for what he said on ditto. This is a text amendment which must be turned into an ordinance to be law. It is similar as far as code enforcement, administrator, official, to what the voters of Josephine County voted down 80 to 20% overwhelmingly against this type of thing. This is too close to that. People should know that County Council did not even draft this proposal, yet his name is used several times in it. Now, 5% of the people are creating 95% of the problems. I agree there are some problems, especially with larger recreational roads, which I'm not crazy about. But why would you legislate something that 95% of the people are doing correctly and are good neighbors? There's various particulars here that I'd like to address. One of them is odor. Odor is irrelevant because the State Court of Appeals has ruled odor is subjective, and no county government, city government can use odor, not even through time, place, and manner. You need to check the Oregon Court of Appeals. As far as things like RVs, compost piles, 2.5 acres, regarding RVs and campers, Dan Young was a city council. He knows the situation with homeless. I echo, again, Cliff Thomason and his view. If you want to increase homelessness, just outlaw all of these compounds. Of course there's safety issues, but you have to look at what is the lesser of two evils here. Now do you do this for all crops? Do you have fencing requirements? Do you have compost pile requirements? Will you evict people out of their land if they're in a hardship situation and haven't applied? Will you evict them out of their land if they can't afford a trailer park? Will you do that? Then you will. This is far more than cannabis. Now, there was a town hall meeting in Cape Junction where more people showed up than were in this very room. And it was made abundantly clear that the county people want as little as regulation as possible, and they don't want it stricter than the state. It's unfortunate you didn't attend, Simon, because you would have seen what your own community would have felt. Lily Morgan and Dandy Young have talked about a very good thing, and that's called the Cannabis Committee. Not the Williams Action Committee. They do not represent the vast majorities of growers and patients in this county. But a Cannabis Committee would. People like myself and Peter Gendron, who works with the state, would be good additions to this before you make any conclusions. The Rural Planning Commission the commission itself did not deny code enforcement officials. Again, private property rights. I live in Selma. I saw a fence of root balls, and that is being used as a bad fence. Yes, it's a fire hazard, but this fence doesn't even belong to a grower. So the accuracy of these complaints are subject. There are 3 agencies right now: the DEQ, the Fish and Game, and the county's own court. Any complaints that are issued should go through these 3. We don't need to give the planning director extra power, making people guilty before innocent. It's good to know this is complaint-driven, but that's how it starts out. When you give government an inch, they usually take a foot. Too much power to a planning director and government to over-regulate what you can do on your property. I mean, what's next? You want a lien on your property? Then you lose control of your property. Again, this is too close to the ordinance that was voted down, and comparing it to a rather onerous ordinance is unfair to begin with. Dogs, guns, and transients, that's been going on for 20 years in Josephine County. Generators go for a month. What about what she hasn't mentioned regarding $500 per site maximum for voluntary compliance? Now, if you're doing everything right, this is literally extortion. Representative Carl Wilson and his aide have felt that if you're doing everything right, why would you give the county money so they don't harass you? Hearings officer, look at the intent behind that. You give an inch and they take a foot. The economic aspect and the medical aspects of the cannabis industry is very important. I sincerely hope that people sign the petition opposing this. You'll see me around. Thank you again.
Good morning. My name is Peter Rostow. I live in Sun Valley. And I moved from Austin, Texas about a year ago. And the reason I moved to Josephine County was because of the limited regulations and open property rights. And I agree with everything the previous speaker said. And I understand that Josephine County doesn't have a lot of extra money. And this just seems like a backdoor way of collecting taxes. Thank you very much.
Yes, purple.
Good morning, members of the commission. My name is Peter Gendron, Sunny Valley. Been a Josephine County resident and voter for over 2 decades now. I also happen to be the president of the Oregon Sun-Grown Growers Guild, which is a non-profit, membership-based issue advocacy organization. We work at the state level, primarily attempting to influence legislation, influence the regulatory process. To that end, I've also had the privilege of sitting on the OLCC's Licensing, Compliance, and Enforcement Commission. I'm probably uniquely qualified among the members in this room to illustrate both and articulate both the intent of the state at the legislative level and at the administrative level. But I really thank you guys for taking the time to look at this issue thoroughly and thoughtfully. I know this was kicked down the road by the previous commission, and I would say that that was obviously partially at my insistence. We did 4 of these meetings around the county last year, getting feedback from the citizens at large. I do not believe the planning department's position on this issue adequately reflects the feedback that I saw at those meetings. We had another blockbuster on Halloween night on this very topic. Some things have changed since then, not much. In 5 minutes, you can't possibly go into everything that's wrong with these proposals, but I can tell you that under attachment B on page 9, when it comes to the mechanical engineer's certification, slightly paraphrasing, it requires a mechanical engineer to certify my neighbor's olfactory enjoyment of their backyard. There are a lot of things a mechanical engineer can do, but that is not one of them. I'd also like to thank Mr. Hurt for his comments on land use and fencing, the way that people view property lines. That could become an issue, and I don't want to belabor that, but I do want to point out that about 3/4 of Josephine County is actually owned by the federal government. My next door neighbor, my back neighbor, is BLM land. Why do I need a 25-foot setback from federal land? That doesn't even make sense. It doesn't begin to. Under the rules from Measure 67 back in 1998, that's where the genesis of keeping plants out of sight originated. That was basically copied and pasted into the OLCC language. The 8-foot fence requirement was arbitrary. The OLCC saw that. They saw that it was unnecessarily complicated, would be an unnecessary additional burden to doing business, and that's why we modified that. There's no reason that we have to have this all fenced off. You can't contain the smell. That month or so out of the year that my outdoor plants do smell. But my neighbor that I've been next to for the last 20 years, who doesn't consume cannabis at all, has never had any problem with my grow site or the grow site on the other side of it. We don't see those fencing setbacks as required. Every other plant, now of course you can't have cannabis hanging over the property line. It can't be hanging over the fence, right? It wouldn't be desirable. It's actually against the law. But why a 30-foot setback or a 10-foot setback or some other arbitrary thing? As was pointed out correctly by planning, this is to be treated as a farm crop. It is an agricultural commodity in the state of Oregon, and I don't really think the proposals that are on the table do an adequate job of differentiating what we've been doing with the medical plan since 1998 from what we're doing under Measure 91 now. Last year was a really unique year in cannabis cultivation in Oregon. You'll never see another year like 2016. There was never one before it, and there will not be another one like it in the future. Some of what's happening at the state level also right now, I don't believe is adequately contemplated with what's currently on the table. And I know there are 18 bills that are up right now. Not all of them are going to pass. Some of them are mutually exclusive. But some of them could be providing guidance to the county on what to do here. Whether we wait and see those pass or take action right now is another question. But I do think that this really needs to be revisited because we don't have consensus on this one thing. Is this about marijuana or not? I heard earlier, I'm very certain come from the planning director that this isn't all about marijuana, except for it seems to all be about marijuana. If you want to avoid the confusion, then make these separate issues. This has already been articulated. There are a number of different departments that already have jurisdiction. A lot of these complaints aren't even really cannabis related. We have thousands, literally, of medical grow sites in Josephine County. You're hearing about a couple of grow sites, a fraction of a percent. If all of the complaints tabulated together were taken into account, you're talking about less than 1% of the county's population complaining about less than 1% of the grow sites. I don't really want to be regulated by the lowest common denominator. Thank you very much.
Yeah.
Yes.
Yeah.
Please, again, encourage you to have those comments in your head.
Hi, I'm Shavonna Feinberg. I'm the co-chair of the Williams CAC. And there are three main things I really want to bring to your attention. The first is that the articles that we're proposing that have to do with the Williams CAC are Article 12, Article 20, and Article 69.5. And those do not have anything to do with marijuana. So the articles that would be giving the CAC, specifically what they're asking for is that the CAC receive timely notification of relevant land use applications in their jurisdiction, that the CAC have the right to suggest to the Director of Community Development that a site plan review process be used when the CAC can demonstrate that an application will significantly affect neighbors or the environment, or that neighbor input would be valuable for the review process. And the only third thing we're asking for is allowing Williams, as you have allowed Merlin, not you personally necessarily, but the Merlin area is an overlay district, allowing Williams, which has the only active CAC left in the county, to become an overlay district, whereby they can propose regulations that support the healthy values and rural nature of their unique community. So these three articles, 12, 20, and 69.5 before you, have nothing to do with marijuana regulation and have nothing to do with rural residential properties. What we're asking is that you separate these. It sounds like the other regulations are going to be a long process. And these are very different, and we're asking you to please separate these and vote on these separately, because they are a very separate issue. The second point is that the state of Oregon has made citizen involvement a prioritized goal for land use planning policies. In their goals, it's goal number 1, citizen involvement. The CACs are a major aspect complying with the state's mandated goal. And because at this time the Williams CAC is the only existing CAC left in Josephine County, its existence and functioning is quite significant to Josephine County's demonstrating that it is following the state goals. On the Josephine County website regarding CACs, and you have a lot of information about CACs on your website, it says, quote, "The CAC may hold public hearings to review and recommend changes in the comprehensive plan for its area." And that is exactly what Williams CAC is doing. It's fulfilling this privilege and this responsibility, which you have specifically given us with the submission of the text amendments, Articles 12, 20, and 69.5. These submissions demonstrate our partnership with you in the local planning process, and that through our collaboration, we can meet the state's goal of citizen involvement. Let's see if I don't say anything like that. Also, when we did go through the Planning Commission hearing, and we are aware that the vast majority of the Planning Commission was in favor of separating these amendments and passing them through on their own. But what happened, as we're afraid might happen today, is that so many of the people here are here to speak about the RR amendments and marijuana regulation that commission got distracted and never actually, at the end, they just said, oh, we can't even vote, we're just going to pass it on to the next people. And they didn't do what they were really in favor of. And we heard and knew that they were in favor of, which is separating these few amendments which have nothing to do with rural, residential, and marijuana regulation. The third point is that Williams, being with cannabis cannabis being an important part of our economic economic environment. And many of our friends and neighbors are medical growers, and some of them are recreational growers. We have been particularly impacted by these large industrial-sized recreational projects coming in from out of state. One of them set up 14 greenhouses with 8 fans each. That's 112 fans that they ran 24/7, literally all day and all night for 5 months, right next to neighbors. We have another situation where runoff has flooded some neighbors and also carried pesticides onto what was an organic farm and may be losing their certification. So we are already in conversation with many of our friends, many of our neighbors are growers. We're in conversation to figure out what can be done to just respect the neighbors and respect the lifestyle. And we hope to come out with some ideas in a collaborative way. But mainly we ask you to separate our amendments and move them on separately.
Which green?
Hi, my name's Jim Moore. Go ahead.
We're going to go with that green first.
Oh.
Okay. Sorry.
Going by
I'm
color.
colorblind, so.
Nobody changed his shirts halfway through the meeting.
Jim Moore. I've been a resident of south side of the river for 19 years and a licensed contractor who just recently retired. I tell you the truth, I feel pretty much like a stranger in a strange land. Things have changed so much since I came here. I believe I have to just speak to a couple of things. One is the need for codes, regulations, and enforcement. Having been a contractor, I know that the reason for those are for public good. You know, that fire codes are developed, implemented, and enforced for the benefit of the public. And so our building codes, and they should be in the relationship to marijuana and the growth, especially in residential areas, that needs to have some input from those of us who live in those residential zones who do not grow marijuana, do not want to grow marijuana, that left that behind in the 70s. You know, that was something we give up because we want a different life. And I would just also, I have a big concern for, I think a fellow River Song mentioned some of that, but the environmental degradation that happens by the deforestation that I see happening in some of my neighborhoods. Moved here because of the beauty, you know, of the residential forestry. Clear cut, I have property that has, I couldn't even name the biodiversity, it's so extreme, you know, with the beauty, with all the different oaks, Doug fir, madrone, cedar, pines, and then all the wildlife, including grouse, which you rarely see, and all this stuff. Well, there's areas that they just clear it out. And then what do they use? Chemical pesticides, chemical fertilizers, chemical, I might have said herbicides, but pesticides, herbicides, and fertilizers. And that stuff just is in the environment. No trees, monoculture, useless. Maybe not useless, but I want to be extreme because it feels extreme what's happening to areas in my neighborhood. Just wipe it out, grow one crop, use lots of chemicals, forget the wildlife. Let's regulate it. That's what I'm going to say. Thank you.
Oh, that's green. I'm sorry. Then we'll go back to purple. That's true.
What about brown?
Thank you very much for letting me speak. My name is Rich Ekman. I live out in Murphy, and I'm talking about the 380 issue too. We were all told that this was going to be a main issue today, and I want to apologize to the people in the marijuana. This has nothing to do with marijuana. This has to do with health, safety, and incompetency. And ditto to the, he's gone now, but to the firefighter, thanks for all his efforts. I'm here for the compounds and hoping the regulations are enforced. We have a situation I've been involved in for 3 years. I've been watching this escalate with an incompetent person who doesn't pay taxes on his property. And he doesn't, I don't know if he pays rent or whatever, but he has no regard for the safety of the residents around there and the people that he's inviting into his home. There is at times up to 15 to 20 people living on a half acre. They're coming and going at all hours of the day and night. And when you go by, walking or driving, they try to influence their will on you and try to start some kind of confrontation. And we've been living with this, like I said, for 3 years. And I have a picture of the leach field that's failing, and they keep throwing dirt over the top when it comes up to the surface. It's very much a health hazard. There's odors. And the sewage, and ditto to Mrs. Outfleet for what she said about it. And the sewage that is running onto her property goes into an irrigation ditch. And so that's another health hazard. We've reported this numerous times to the DEQ and nothing has happened. So we are at wit's end on what we can do. And we're hoping that this gets resolved. And thank you very much for letting me speak, and thank you for your service.
Thank you.
Hello. My name is Rebecca Teresa Renborn, and I live in Williams on Kincaid.
Rebecca, what was your last name? I'm sorry.
Renborn.
Renborn.
Yes. And ditto to Pioneer Pete. What he said, about odor in particularly, I'd like to address that. We noticed, last year when we were coming back from Medford and Ashland into the area, when we would turn at the Provolt store and head up to Williams proper, that we could already begin to smell that wonderful fragrance. To call it an odor is rather a negative connotation. It sort of reminds one of malodorous, and I think a fragrance is a much better description of it. It is a beautiful herbal fragrance that smells wonderful. And so I think to some people perhaps it has a negative sort of value to them because of maybe a hangover from the Prohibition days, and they still hate it, don't want their children to be exposed to it, and so forth. And so maybe there's some negative emotions involved with their interpretation of it as an odor rather than a lovely herbal fragrance. But when you turn into our area in the late summer and early fall, the entire area is permeated with that beautiful fragrance. And so to require any one grower or all growers to mitigate the so-called odor isn't really going to change anything in the Williams area, because the whole area is just fragrant in that part of the year. And if people really object to it, there are many, many ways that they can mitigate that odor in their own home. It's a hardship for some people, I've heard, to close their windows at that time of year. But maybe they could put some sort of filter in their window that would filter odors, or a lovely aromatherapy going in their home. I mean, there are many ways that they wouldn't have to smell that delicious fragrance. And I think it's an onerous burden upon the growers to require them to individually mitigate an odor that permeates the entire area. Thank you for your time.
Thank you for your testimony. The gentleman did.
My name is Don Jackerini, 358 Murphy Creek Road, concerning the property at 380 Murphy Creek. The other two people that spoke here before we've all dealt with this. We're all within a rock's distance of this. Concerning the compounds, concerning what's going on there, raw sewage, the criminal element that brings with these. The other thing is there needs to be some enforcement. We need to have somebody to have the power to go in there and roust these people out. They're bad. They're creating bad stuff in the environment. They don't give a damn. They're in and out. And there is like I said, a criminal element there. We have 4 other neighbors that are all within a rock's distance, and they're all the same feeling. We need to have some sort of authority to come in there and deal with this crap. It's bad. Thank you.
In the back. So I'm probably going to encourage people to not use specific addresses and such. There's a time and a place where that just, I can see a back and forth if there's neighbors in the audience. That doesn't sound like fun or what we're here for today. If you use a general example, I kind of get the picture, and maybe we'll just leave it at that. Sir.
My name is Christopher Roll. I live in beautiful downtown Kirby. I am an OLCC recreational grower. I had a lot of help from the zoning and planning department when I went through the paperwork to become licensed. I had help from OLCC, from the water rights. It was actually a pleasant experience. I don't find that where I come from. I was really surprised everybody was so helpful. So I'm one of the evil rec growers that you're hearing about. But I don't think there have been any complaints about my grow. It's a half acre, RR5, and I tried to get a list of the complaints from Julie's office, but wasn't successful with that. Just some background. My family came to this country in 1620, and I came to Josephine County in May 2016. I retired from the military in 1997 and have been in business for myself in Florida in the plant business for 20 years. Then I decided to have a midlife crisis, so I came out here to grow weed. And it's been a great experience. The only problem is I haven't been able to go back to Florida for the winter, so I'm still here. So the 3 points I want to make on your amendment, which I've read more than once. Number one, Julie mentioned that medical grows were grandfathered because of the substantial investment they had made. Well, I don't know if she keeps track of numbers or not, but I can tell you setting up a recreational grow, including buying property, is also a substantial investment. I bought a house that was in foreclosure, built in 1910. I've been renovating that house. I'm actually raising the bar in my neighborhood as far as how things look. And I know when I first came out here and drove down Highway 199, I thought, this is paradise. And then I started seeing all the junk cars, and I'm not talking about GTOs and Mustangs and stuff like that. I can appreciate those. But I'm talking about just basically trash and garbage. And that whole highway is just lined with places like that. So I would say that would be an honorable goal for the city, and not the city, there is no city there, but for the county to do something about all that. Now, anybody that's been paying attention to what happened in Colorado, Washington, Alaska, knows that there is a growing period for a new industry. It takes a year or two, maybe 3, to figure everything out. But what I see you guys doing is kind of a shotgun approach to it, not working on individual issues. So when I was a submarine sailor for 20 years on nuclear submarines, we had a lot of rules to follow. I believe in rules. They're there for a reason, and I generally follow the rules. So I just recommend that you guys focus on where the problems are and not try to rework the whole situation. And the last thing I want to say is, in this amendment, you talk about moving the growers out onto the ag land and the forest land, and that's a great theory, but you can't just go out and buy a couple of acres in those areas. You can buy a house, a barn, and 40 acres. That's pretty easy, but you can't just get generally a few acres to set up your business. And then you also have water rights to deal with and electricity. So the small players in this, like myself, and I've got probably 100,000 into my business right now here in Josephine County, we would not be able to go out to those areas and buy 20 acres of farmland or forest land or whatever. So you're going to eliminate a whole group of people. One last thing, you're sending a bad message to potential investors or people that are already here that want to expand. Because why would anybody want to put money into Josephine County if the situation is not stable? You need a stable environment where you do what you say you're going to do, and you're not changing things because you get a few complaints. Deal with the complaints, enact whatever code you need to enact to clean the place up, and that's all you should have to do. Thanks for your time.
So I want to give the board and the public an opportunity. So I see this going on for a little while, all the evidence so far, and it's been good. I appreciate people coming and testifying. I think we could probably schedule to do this up until noon, the noon hour, for the next about 30, 35 minutes, and then take a break. My schedule can reorganize the afternoon to come back. What does your guys look like?
I'm open till 3. Hoping it doesn't go till 3. I'm open till 3.
Went on the break, I told him to move my 1 o'clock and make it available.
So
there's a lot of people that have come a long ways to testify, and I would just as soon get that out of the way today.
I'm willing to order a pizza and keep going, so.
So we will break for lunch, and I expect to do that at 1 and noon, and we'll come back at 1 o'clock, just an hour. We'll keep it short, and we'll resume after that. So I apologize for those who didn't get in already. We'll take the woman in brown.
It's time for Brown.
Time for Brown.
We heard you.
I'm not here to represent myself. I'm here to represent the children, the trees, the water. My name is Tamara Murphy. I live at 2800 East Fork, and that's in beautiful Williams, also known as Land of Fences. Okay, so what brought me here is my husband's a police officer. He's retired. He was hit by a truck. And let's see, we could ask, I wish you'd wear t-shirts because you represent Zonte and you represent All Care, correct? Because that's where you got your funds from. No. So we're really barking up the wrong tree about medical marijuana, in my opinion. Now we have a hired member of this New World Order here that's working with 50 people. They're called the CAC. They were voted in by 28 people. Those people are gone. Now they've been appointing people. And I'm telling you, I moved here because I don't want to be dependent on the grocery stores. That's why I moved out here. I'm a rancher, but I don't have cows because I'm a vegetarian. So I have a strange situation. My husband takes marijuana for his pain. They had him on 8 different drugs, and they were going to kill him, just like they did my mother. But I don't think it does anything but make him not care that he's in pain. But he's happy, and he can do his little grow. I don't have to do anything but fertilize it. Come and make my natural fertilizer, then I'm probably going to hopefully save the world with. I'm going to tell you one thing to look out for when you come our way. First thing is look behind the grows. Look at all the dead trees. Now I want to see some ordinances, but not the ordinances that you would find in town. Now we don't have ordinances in Williams, and that's why a lot of people chose Williams. Now I'm very upset that these CAC have chosen someone who's an appointed, is paid and is part of your, not your commission, but part of the planning commission, and they're working with this woman, giving her not only ideas, but taking her ideas. And I'm telling you why this is wrong. It's wrong on many levels, but it's wrong because these people are making decisions for our community. They did not do one single petition. And if I have to, if you guys don't want to do this, I've already got 40 ranchers behind me that will petition. And it's for 3 things. It's because they should have to grow above ground so that they don't kill the trees. And I don't care if you're organic, inorganic, that stuff grows like a weed. You don't have to put anything on. But however, the pH of the soil has to be just so for the trees. Now the children, there's one already. And these people, the CAC, got involved when they should have left a lawyer. And they caused a man $80,000 grief. and another man a lot of embarrassment in the community because they wanted to talk about it. They should have let a lawyer talk about it. This man was not breaking the law, and neither was the other one. But I want to see on the books in Josephine County, I don't care about these other counties, 1,000 feet, whether it's a grow, whether it's, we don't have any of those dispensaries, but if we should get some, and then if it's, say if I'm just processing, 1,000 feet from those children, and that means a parking lot too. And if it's not done, we will go the same, we're not going to get an overlay, we're going to do what the law says, and we're going to petition and get what we want. And if you guys don't do it, we'll get some new people in there that are going to give us what we want. The next one is, now I don't know if you guys know, but there's innovation out here, and they have machines that run, fans that run, that are so quiet if they are, and it'll stop. And I want to see that. I moved out there, not for my cows to be wandering around at the light, looking at the greenhouses, oh, how pretty. No, the cow, it gets screwed up that way. So, first of all, when it comes to the greenhouses, do you know how easy it is? Take some black plastic bags, a dowel rod, and I cover that up at night. I live 3 houses, which is about 20
Get back on the mic so we can hear you, please.
20 acres. You know me, I don't need a mic. 20 acres from this grow. I don't need a flashlight at night to go out on my ranch. This is criminal. I don't care if it's a personal grow. I don't care if it's an industrial grow. Us ranchers are PO. Our cows are up all night wandering around, don't get back to the barn. And then I'm outlined, anything can come and eat them because they don't make it back to the barn because they're staring at the lights, wondering what it is. Now, again, it might sound trivial to you, but it's a big deal when you're a rancher. Now, you look around and you're going to see, okay, look at all of these, all they're covered. Got these ugly fences everywhere. The plants didn't do anything wrong, but for some reason we have to have ugly fences everywhere. Okay, what I want to tell you is, you guys might not know, 50 years ago, this same stuff came up. They were going after the ranchers because the cows pooped, and they smelled, and people would leave them dead, because they just wanted the dairy. Same thing, and I want to know, when is it going to stop? When are these regulations going to stop?
Thank you so much. Thank you.
One other thing, before I go.
Sorry, your time is up.
This is for the trees.
You can actually put those things in writing, and you can submit it to the board, bcc@co.josephine.or.us, but otherwise your time is expired. Thank you so much. We'll go to the next person. We'll go back to green, right here in the front row, and then we'll go to you, Miss, right after, behind you. It's a green jacket, right?
Yes.
Why? Green. All I see is green. It's okay, man. I'll answer to green. It was black. It is black.
No, I think it's green.
Well, sorry, the lighting. The lighting, we'll go with that. Hi, Dan Lochran, Williams, Oregon. First of all, I'd like to welcome the new commissioners, Ms. Morgan and Mr. Young. Thank you for taking your time and your effort to come in and jump into the snake pit. Let's go back to where this whole thing started. We need a little review. There was 4 meetings in the county, which started in June. And you'll notice on the slide that June 8th was when the manipulation of the rural residential property started. At 3 of the meetings, one of which you were at, Ms. Morgan, it was clearly stated by the commissioner with a substantial conflict of interest, said we are not looking at rural residential property at this time. That was the biggest piece of Pinocchio squeeze I've seen. Look what's come out from 6-8 before all the meetings were even done. The meeting here in Grants Pass, the exact same was said. The meeting in Cave Junction, the exact same thing was said. 3 times I went to those meetings and it was stated. And she was, no, we're not. Directed directly to her to go after rural residential property. I absolutely echo, wherever this governor, whatever he was, and Mark. These are personal property rights. I moved here for that specific reason. I looked at Josephine County because of its regulations. I bought property that was flat, plantable, with a water right and exposure. Not to grow cannabis, I grow lavender, another plant with a substantial smell. I won't call it an odor. I also have been affected by the rural residential and having commercial cannabis inside my residential zone. It is not appropriate.
I get it. The woman who has her son and has to make a living on it, absolutely. I understand it. But the impacts that have happened to my property from this recreational grow, which has substantial violations known to Mrs. Schmelzer, who does not have the ability to enforce them. Substantial safety violations. Substantial, not little ones. Had injuries to employees. No workers' comp insurance. None of them. All of this is coming onto my property from the removal of a swell from 50 years old. No civil engineer was taken out to put in this flat clad for the greenhouses to be put up on. No civil planning was done to remove a culvert and reduce it and then raise the driveway. None of that. This woman is working handcuffed, shackled, and then put into a bucket of water. When are we going to get in an enforcement? It's not working. We can regulate all day long, and you can't do this, and you can't do that, and you can't. But who's going out to put it into the paper and say, no, it will not work? The complaint issue. I keep hearing it. We have lots and lots and lots and lots of complaints. Lots of complaints on this, lots of complaints on that. In one of the meetings, we actually had an official 100 complaints. And thank goodness somebody did the math for me. It comes down to 0.0014% of the population of Josephine County was complaining about this issue. When asked, how many people are complaining about dog barking or speeding? Oh, I don't know. Let's put our money where it really matters. We're going after something that's really, really small. I get it. Cars stacking up, that's ugly. I don't want it next door to my house, but that's where they're living and that's their property right to do so. They want to put up big pieces of root ball, okay, not the smartest thing. Fire hazard, absolutely. Site hazard, site vandalism, yeah, okay. But is it my property? No. It's something I have to drive past and say, no, that doesn't look so nice. I control mine. When somebody else's issue comes to my property, then it becomes problematic. Then I have to be one of the official complaints. Is it against the cannabis industry or just a bad property owner? That's where it gets down to. Please take your time with these issues. Please break them out into very individual issues. I recommend separating the Williams CAC request. It's something that the community looks at and says, yeah, we're behind it. So please take that into consideration. Thank you.
Back in the back in blue, green hat.
Hi, my name is Miles. I'm local. I'd like to thank you for letting me take the time to talk to you because I'm concerned about something.
I didn't catch your name, Miles. Miles what?
It's Miles.
Your last name?
Is that necessary?
If you don't want to.
I prefer not to.
That's fine.
Thank you. I come here in the greater public interest. That's really why I'm here. I myself, I don't have land, but I realize, as per the video that we watched earlier, it was the Enabling Act or the Admissions Act, the method by which the government gave us the land. This is the law. What I want to talk about is the law, not policy, not code. I want to be sure that you guys are doing what you're supposed to be doing. I don't know how to better phrase that, but the land patents. You're already talking about making more codes when it hasn't been laid out for me how it is you do have the authority to infringe on somebody's land patent. So I would like that in writing.
We'll get that.
Because land patents are different. They do differ. And if it is an agricultural issue, you need to go to each individual land patent and not just the Enabling Act or the enactment where it's different in Oregon, I forget. But that is the thing to do. Thank you.
Great, thank you so much. In the back. I'm just going to encourage you, Miles, to reach out to our legal counsel for land patent information. He's the gentleman in the red sweater over there.
My name is Anna Formachon, and I'm a member of the Williams CAC. I'm the meeting secretary, so I've been present at all the meetings and taken notes. I would like to ditto what Stephen Williams and Shavana Feinberg have both said about separating the articles. Don't want to go into that anymore. I would actually like to give a little bit of history from the work that we've been doing as the CAC, just to give you a bit more of an idea of what's been going on. And it started pretty much back last September when we had controversial issues around processing plant application that was going to be put in the centre of Williams. And through the residents of Williams being very concerned about this, and as Stephen said, lots of neighbours are falling out about it, we actually held a town meeting on October 18th, which addressed not just that, but also our concern around us being able to receive applications in due time so that we can actually look at these before it becomes a problem for the neighbours and the town in general. And at that meeting, we took a general vote. It was a visual vote, people raising their hands, and asked them if they were interested in us asking for these applications and being able to have Julie Schmelzer change something to be a standards and criteria, meaning that neighbours could have their input around such applications. And there were 68 yeses, 8 noes, and 1 abstaining. There was way more people in the room than that. But it just gave us a general indication that that was something that those that were present were wanting us to go ahead with. We also at that time took a list of email addresses for people who were interested in becoming a part of something which we later called the Vision Council, which was to look at how we could work on creating something of an overlay for the Williams watershed. 50 people or more signed up at that, and so I began to start relaying this information to those people and other people through other forms of media that we've been active on, such as something called Joe's List and Facebook. We sent a letter to Josephine County on the 27th of October asking for these applications, and then the 31st October meeting that happened here, both Shana and I were there to represent the CAC, and we asked for our articles to be separated, and the unfortunate thing of it not being able to be separated at that time. On the 1st of November, we had our first Vision Council meeting, which was widely attended. There was over 45 people there, and there was a lot of intelligence and heart-founded communication going on in the room between local residents and neighbours, people's concerns being voiced. And at that meeting, we decided to concentrate on what was long-term issues and what was short-term issues, and we created groups to look at those. And we've had, all in all, about 12 meetings, which includes some small meetings with groups that were formed originally from that Vision Council since November through to this time, including our last town meeting, which we had, which was a town meeting, it wasn't a Vision Council meeting, where we asked again whether the residents of Williams were willing to support us as the CAC to go forward in asking for these applications to be forwarded to us and creating an overlay to look at things like light, sound, and traffic problems that have really become issues for neighbours in Williams. And we had, there was more than 50 people in the room, but we had 50 people say yes and 4 say no, and that was a closed poll, no visual, no just raising of hands. I'd also like to state that we are, as volunteers at the CAC, we do our best to inform the residents of Williams of our movements and what we're planning and how we would like to communicate with them all. We're working on outreach and helping to get to more people than we have been so far. And what seems, at one of the Vision Council meetings, well, at all of them really, what seems to be kind of a unifying desire of residents is that we live in and appreciate a rural land, and we live on which merges with wildlands, and to live peacefully amongst each other and have respect for our neighbours. Thank you.
Thanks for not letting me, we felt that way. So there's some conversation going on in the foyer, and maybe we can, there's plenty of seating in here, so maybe we can close those doors so if people want to. Gentlemen, I think it's mostly men. Thank you, that'd be great. So we're going to go to the gentleman in the hat. Sorry, it's just luck.
Make it quick. My name's Bob.
The other gentleman in the hat, yeah.
Oh, me or the other one?
No, you.
All right. My name's Bob Bell. I live in Cape Junction, 6020 West Side Road. I was one of the first ones to use the restroom during the break, and I found some money on the floor. So, did anybody lose any money in the bathroom? It's not a lot.
$4. Right. And there's towards the GTO. Hold it together.
Yes, it is.
Do steer whip, no.
That's it.
Do you have further testimony for us?
Yeah.
No.
Awesome. Go for it.
Okay, moving right along.
Actually, it's $5.
Somebody in a hat over here. There you go.
I think you should
Sorry.
keep it. You were so honest to say you found it. Thank you very much.
I also have some money too.
Put it in your pocket.
We're in the money business.
My name is Rick Friedman. I live in Murphy, and I'd like to talk a little bit about today about not necessarily what the staff is recommending, but enforcement. I built a house. I've lived here for 10 years, and my neighbor had a unhabitable mobile home that burned down. It was next to my house, and behind that mobile home there was 100 bags of hemp. And luckily the fire department came out and put the fire out. Otherwise I wouldn't be here today, and neither would my house. It's very important to follow rules and laws. This is the 2014 Oregon Structural Specialty Code. This is adopted by the state of Oregon for building. There's another code for residential. It's the same size. Together, those make up the building code requirements, and they do have setbacks. Setbacks are very important. This is the 1964 Uniform Building Code, probably adopted many, many years ago, and you can see we've come a long way in the past 50 years. We need to continue to progress and have laws and rules and regulations, and we need to enforce them. We all know that there's 11 million people here in this country illegally. They've come across the border, and now we're going to have to build a wall and spend billions of dollars. We need to enforce our laws. It's very important. In Oakland, California last year, there was a fire in a commercial building in a warehouse that was converted to an apartment building. People lost their lives because they didn't follow the building code and because they didn't have inspections. Inspections and codes are very important. I understand that there was 2,000 illegal grows last year in Josephine County, and about 100 people had actually legally got permits to do a grow. If you have 2,000 illegal grows in the county, there should be something done about that. You should be able to enforce those so that people abide by them. We should have building inspectors to come out and make sure that they're doing it right. The building codes have a whole section in grading. Grading is important, erosion is important. If you have 2,000 illegal grows and you charge a building permit fee for a fence and a planning fee to come out and enforce what's done, that's $700,000 that the county missed out on. Has nothing to do with taxes. That's just building permit and planning costs. I beg of you to enforce the codes and also approve what the planning department is recommending. Thank you very much.
Thank you. We're going to try to take two more people. Black jacket, one here.
Mr. Hare, she's had her hand up almost every time that there's been a change, and you haven't looked over here.
I I was actually chastised by this side of the room because I was looking over there.
I know it's
So,
dark, but I mean,
you know
come
what?
on.
I apologize. It just is what it is. I should say before we get started is that if you're not able to stick around for this afternoon and you want to submit testimony, we really want to hear from you. And I apologize that I didn't get to the woman in the second row over there. But we will. But if you can't, please submit your testimony to the Board of County Commissioners at the BCC at co.josephine.or.us. It's on our website. We have received more than a dozen comments already on that way. Thank you.
I'm Sandy Diesel. I'm the director of Right to Grow, and I'm also a founding partner of 420 Consultants. And I did much of what Cliff Tomlinson said earlier. Mark Siegelman testified, Mr. Lochner here. This is not a marijuana issue. This is a property rights issue, and unfortunately it's a bad neighbor issue. You have no easy job in front of you, commissioners, as I'm sure you've witnessed with Jackson County. Everyone here has a right, but as Mark testified, 95% are doing it right, and 5% that are doing it wrong does not justify unreasonable regulations. Julie herself has said nearly 90% of those complaints were actually legitimate complaints. And, you know, people just complain to complain sometimes. Most times I find that they don't know what the laws are. The 14 greenhouse grow, we've all heard about it. I know, from a professional standpoint, I consult them. And what most people don't know is they are not violating any existing code. They're doing it right. They did it right when they came to our town, and they've researched what the current code was, and they're complying to the best of their ability, and they're being good neighbors. The guy Lochner talked about earlier, that they are trying, guys, come on, they're trying. The other complaint we hear a lot about is Mr. Lochner talked about the person that came in from out of state, didn't listen to good neighbor advice, saying, hey, you know, if you grade that land, we're gonna have a flooding problem. Hey, if you build a greenhouse, we're gonna have an engineering problem. Or hey, we have a fire problem. Those are real legitimate complaints. And people are coming into our town and they're just not being good neighbors. And now we have 8 properties that are flooding because of a bad neighbor. It's not a marijuana problem. This is just really a people problem. It's a property rights problem. We heard testimony from Ms. Brown earlier, obviously very upset, very passionate. What I take away from her testimony is that we need to educate growers on how to be better growers, to teach them about the soil and protecting our property. The fact is, there are just bad people, and it's not a criminal element in our industry. Do I look like a criminal? Those people affect my right to grow. The people that come in here that are doing it bad just because they're bad people and bad neighbors are bad for us in the industry also. The woman you heard earlier that has a very sick son, that this medicine is saving his life and giving him quality of life, affects her right, their human right to medicine, their property rights. One bad apple, you don't cut down the whole orchard. You try to make it better, and you make it better for all of us. My advice to you as commissioners is to please take your time on this. Educate yourselves. Educate this community. You will find that if you educate the people, you'll get a lot less complaints. You cannot create, I heard the last gentleman say about enforcing, he's absolutely right. I see a big problem we have in Jackson County is enforcement issues. You cannot create regulations that you don't have the ability to enforce. You cannot overstep your authority when it doesn't belong to the county, when it's a state level or an ODA level. So my advice is that you work with those authorities, and it's not going to be an easy job. Julie has told you that the county literally has no communication or support from OLCC or the OHA. You have no easy job. So my advice is to really take your time on this. Whatever ordinances you create, consider a grandfather clause for the medical growers. Consider a grace period for anybody that's not complying, that you give them a reasonable period of time to figure out how to comply. And at the end of the day, I really think that really what has to happen here is that we all need to come together and be better neighbors. And that's going to start and end with you, commissioners. Thank you for your time.
Just one more person. The woman who obviously paid advocates and.
I thought if I could.
We will reconvene at 1 o'clock right here when we're done. So we'll resume the testimony.
Hi, my name is Ginger Edlison. I'm here with a few of my neighbors, and we have a complaint about a property on Campside Road at 3344. This property has a school bus that's been there for 35 years probably, an old mobile home, single wide. They've moved in 2 campers and a mini motorhome. There's probably at any time 7 to 9 cars and junk piled everywhere. There's children's play equipment there. And our concern is, we know that that's against code to have that many pieces of equipment on probably a ½ acre. Plus the fact that where are all these people going to the bathroom? And it's just, if you just go drive by it, it'd make you sick. And we'd like to have something done. We've been calling, bugging the people. And I guess they can only do so much. But that's our complaint, and hopefully something will get done about it. Because children living there under those conditions, besides, it has to be a health hazard. So that's all I have to say. Thank you.
Okay. Want to appreciate everybody's patience so far. We're going to reconvene in 1 hour at 1 o'clock. So we'll see you here.